May I please, my lord?
Yes.
May I
Yes.
please, my lord? My lord, I would like to mention item number 11, man.
Yes. What is this matter about?
My lord, I am for the petitioner, my lord.
You are for?
I am for the petitioner, my lord.
Okay.
Consent has been taken, my lord.
Okay. What do you want? Consent for what?
Adjournment, my lord.
Adjournment.
Yes, ma'am.
For how much?
My lord, after 2 weeks, my lord.
Mr.
M. Doji, man.
Your name is there?
Yes, reflected here is Margadi, man.
Hmm?
Reflected as Margadi, man.
Okay, Mardi. Okay. Mr. M.
M. Doji, man.
Doji, Land Council for the Philippines, with the consent of the other side, prays for adjournment of the matter for 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
My lord, another item number 13 also, man.
Similar prayer?
Yes, my lord. Here also, my lord, I have taken consent from the petitioner, man.
Here you are for the respondent.
Yes, my lord. I am for the respondent number
Okay,
7.
Mr. M. Doji, Land Council for the respondent with the consent of the Land Council for the petitioner. Adjournment for how much?
After 2 weeks, my lord.
Okay, similar. Land Council for the respondent, huh? Okay,
My lord, item number 14, man.
14.
Yes, ma'am.
14 is in order. Let us see. What? Why you take adjournment here? What this is for listed for?
My lord,
For what?
we are supposed to file
Hmm?
implement of the new incumbent, man.
You are for
I am for the petitioner, man.
petitioner.
Yes, ma'am.
You have to implement new.
Yes, new incumbent, man. I am supposed to file implement for new incumbent, man.
Okay, not yet filed.
Not yet filed, man.
You have made such prayer earlier also.
Last time, yes, my lord.
Okay, Mr. M. Doji, Land Council for the petitioner, prays for further 2 weeks time
Yes, my lord.
to file implement it, so IA for implementing of the new incumbent as the respondent party in the present contempt petition. The prayer is allowed. List this matter after 2 weeks.
All right.
Okay.
Mention, my lord.
Yes.
And I beg to mention item number 16, my lord. Here, my lord, I am appearing for the respondent number 5 for the first time, my lord. I am praying some time, my lord, to file affidavit in opposition, my lord.
Okay. Who is for the petitioner here?
My lord, I am appearing.
Okay. So, Mr. T. Tobun, Land Council for the petitioner is present. Mr. Lising Perme, who appears on behalf of the respondent number 5. And
5, my lord.
oh, sorry, 5.
5.
You have received the copy.
Yes, my lord, I will.
And on behalf of the respondent number 5, and prays for some time to go through the petition and to respond. The prayer not objected. Accordingly, the prayer is allowed. List this matter after
3 weeks, my lord.
3 weeks.
My lord, interim order passed earlier, may we continue?
The interim order passed earlier shall continue till the next date of this case. Okay.
Oh, yes.
May I, my lord? My lord, I beg to mention item number 10.
Yes.
I'm appearing on behalf of K lawyer for the petitioner. He is out of his station, so kindly matter me adjourn for today.
Who is for the other side?
I have taken consent.
Okay, you are Mr.
P. Harming.
T.
P. Harming.
Your name is not there.
Not
Mr. P.
Harming. Harming.
Land Council appearing on behalf of Samis. Conducting counsel, Mr. K. Lawyer, he is out of station. Therefore, pray for adjournment of the matter. For how much?
3 weeks.
3 weeks. He has also obtained counsel from the Land Council from the other side of the other side. He is prayed for come and list this matter after 3 weeks.
Yes. My lord, there is an interim.
The interim order passed earlier will continue till the next date of listing. Okay.
Deeply obliged.
Mano, I'd like to mention one unlisted, which may be the.
What is this matter about?
That is, for just to, withdrawal. For
For
withdrawal.
notice,
Yes, ma'am.
for withdrawal.
Yes, ma'am.
Okay.
May I please, Lordship,
Yeah.
Lordship, I beg to mention item number 20 on behalf of T. Pertin. Matter may be adjourned for 3 weeks. I've taken the consent from the opposite party.
This item
20.
20. You are for the petitioner.
Yes, Lordship.
Okay, you are Miss
M. Body.
M.
Body.
Land Council for the petitioner with the consent of the Land Council appearing on behalf of the other side. Praise for listing this matter after
3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks.
Obliged, Lordship.
Beloved, I'm mentioning item number 15.
Just a minute. Her name appearing on behalf of Mr. Tony Party, Land Council for the petitioner. Her name is not there. Yes. Yes.
Beloved, I'm mentioning item number 15. The conducting council G. Kato is out of station. Consent is not obtained, Your Lordship.
Okay. You are Mr.
I'm mentioning on behalf of G. Kato, Your Lordship.
Okay. But still then kindly tell me your name.
P. Ronia.
Okay, Mr. P. Ronya, appearing some is that the conducting council, Mr. T. Kato, Planning Council for the petitioner, who is out of station, therefore play for adjournment of the matter for
After 2 weeks, Your Lordship.
2 weeks. He has also obtained consent from the Land Council of the other side. In view of the above, the prayer is allowed. List this matter after 2 weeks.
Deeply obliged.
This is all. Yes. Item 1. After some time. Let us wait for some time. Okay. Maybe in some other.
May I please, ma'am?
Yes.
So, my lord, the case before the lordship is pertaining to the transfer matter. But in this case, normally lordship know that the transfer matters are trying to stay the transfer. But in this case, I am praying before this lordship to effect the transfer order. The transfer order was already passed in the 13/8/2024. Despite of the transfer order, but I have not been released by the concerned authority. So, my lord, may I kindly come to the page number. My first appointment order is in page number 13, my lord. 1-3. There was a mass appointment of the teacher, and accordingly, by the order dated 8 May 2020, I was appointed, and my name is appeared in page number 14, wherein, my lord, serial number 373, my lord, last column, page number 14. And I am the Pole Science teacher who is posted at Government Higher Secondary School, Talomal. Thereafter, I have been serving in the same school, my lord, for last 5 years. Now, my lord, may I kindly come to the page number 16. This is the last transfer order. This transfer order was passed on 13 August 2024, and my name is appeared in serial number 3, my lord, serial number 3. That I was transferred from Government Higher Secondary School, Talo, to, my lord, Nirjulu here, my lord. Now, despite of that, my lord, I have not been released. Therefore, my lord, attempt has been made. Initially, my lord will find in the page number 20 that by approaching the, my lord, Deputy Director of School Education, that why I should not be released. So this WT message was also given from this Deputy Director of Secondary School Education that I may be released, my lord. That appear in page number 20, my lord. Thereafter, my lord, The reason, what is the sole reason, my lord, not to release me is that, my lord, that no reliever has been, my lord, posted in my placement. Now, if my lord come to page number 21, here, my lord, page 21, and this is the order of 2nd June 2025, wherein, my lord, appear in serial number 7, one Srimati such and such has been, my lord. In remark, my lord will find as reliever of Srimati Pisayajic. It's me, my lord. So reliever is also been already, my lord, transferred. And report has been made, even the approach to the Deputy Commissioner of the K panel, my lord, in a representation was made on, my lord will find in page number 23. So, my lord, this is the writ petition, my lord, seeking direction direction particularly to the respondent number 4, the principal of the Government Higher Secondary School Talo, to direct how I should not be released from the, my lord, Kensal School.
Yes, Mr. Yes, Mr. Tupai.
My lord,
So release him,
my lord,
release her.
my lord, let the authority release, my lord.
Hmm.
My lord, my lord,
You are
direct,
representing the authority.
my lord. Uh,
What is the hurdle, the problem?
my lord, that I could not contact the authority concerned. What
Okay.
is the reason for not releasing, my lord? So it seems that it's because of non-joining of the reliever, my lord.
The reliever now already transferred.
My lord.
Will dispose of.
My lord.
Okay. Hard, Mr. Okay, SC Modi, Land Council for the petitioner. Also hard, Mr. Etagum, Land Standing Council, Education Department. Okay, I'll pass over. Within 3 weeks, huh?
My lord.
May I please, Lordship?
Okay.
Lordship, this is a writ petition filed by the petitioner who was a casual laborer under the Department of Power, under Executive Engineer, Raga Electrical Division, Department of Power, Government of Arunachal Pradesh.
Hmm.
Lordship, the fact of the case is that, Lordship, on dated 23/3/2025, there was an electrocution of a person, namely Game Sakhtar, at a transformer located near CO's office, Campo Rijo. And in that electrocution, the said deceased person, Game Sakhtar, died due to electrocution. He was a public of that particular electrical transformer. There was another person who was entrusted to engage.
Any action taken against that another person?
Yes,
What action?
that is one Srimati Getam H. She was the person who was entrusted to the electrical transformer.
What action was taken to her after the incident?
I was suspended because
And against the one who is responsible,
nothing has been done.
but the inquiry report found that you are You are the responsible person.
Yes, Lordship, because there, due to the death of that said person,
Hmm.
there was a public hue and cry in the locality. And because of that, those
What is your prayer?
no so-cause notice has been issued.
Where a casual worker, notice need to be issued to the casual worker.
Lordship, I have quoted the Supreme Court judgment in State of Karnataka versus Uma Devi, reported in 2006 for SSC 1,
What it says?
that the employees who has completed the 10-year service
Hmm.
of their service, the so-cause has to be issued by the authority. Lordship.
Even if the person is
Yes.
on casual basis.
Lordship. No opportunity has been given to me. In fact, Lordship, I was the person who tried to save the deceased person, and in the process, I was also was also admitted in the civil hospital at Zero, Yaditaka Hospital at Zero. So my respectful prayer before this honorable court is that the suspension order may be stayed. Impugn order may be.
When it was suspended?
It
No,
is,
April.
yes,
After this can- that can be-
15
It can be stayed. Yes.
15 April.
Yes, Mr. Mishra.
At the issue, my lord, I humbly believe I require instruction, my lord. Notice me.
Notice that. Ask Mr. Itaba, land council for the petition. Challenge. The impugn order dated. The order dated.
15 April 2025.
15/4/2025. Passed by the executive engineer. Electrical, Raga Electrical Division. Department of Power. Raga District Company. The petitioner also prays for. Seek direct to the respondent authority to reinstate the petitioner's service in his original place of posting. Issue notice. Returnable in 4 weeks. So, Mr. El Parme, Land Standing Council, Power, Department of Power, appeared and accept notice on behalf of the respondent number.
Yes, Lordship.
All the respondents, number 1 to 6. No formal notice need be issued to the respondents. Mr. El Parme, Land Standing Council, prays for 3 weeks time.
3, my lord.
Some instances will file affidavit in opposition. He will obtain prays for 4 weeks time to obtain instruction and to file affidavit in opposition if they stop. List in view of the law, list this matter after 4 weeks. Okay.
Lordship, my interim prayer may be kindly
What is the prayer?
for suspending the impugn.
Suspended already in the month of April. How can that be?
Lordship.
You probably have to satisfy. The so-called notice is required to be issued to the casual worker. You have to satisfy that word probably. Next is
Lordship,
not required probably. Okay.
on the next date, interim may be kindly considered, Lordship. It may be kindly.
Interim cannot be.
On the next date, Lordship, it may be kindly repeat in the,
What is your interim prayer?
to suspend the impugn order of suspension.
He is already under suspension.
It may be stayed. Lordship.
No,
Because I'm the on.
probably this is not a complicated matter. We'll dispose of, if they file opt-in instruction and file affidavit, can dispose of,
Lordship.
because only one grievances to reinstate, isn't it?
Relating to non-payment of salary as per the refixation of pay 6 and 7, Central Pay Commission, Lordship. Petitioner was joined in service as a helper in the year 1986, Lordship. Thereafter, he was promoted the mechanic grade 3, Lordship, in the year 98. He was promoted grade 2 mechanic, Lordship, 8/9/2022. Petitioner was doing his salary and grade pay in the existing fixed pay, but not in refixation of pay under 6 and 7 pay, Central Pay Commission, Lordship.
Or at the same time,
Lordship.
whether the case of the other has been fixed as per the,
Similar situated person already has been drawn, Lordship, 6 and 7 pay commission.
why you did not make any representation at that time? Now you are retired.
Yes, I am retired, Lordship.
Now,
That was the time I have filed a representation before the competent authority, Lordship. I have been stated, Lordship, paragraph 7, Lordship.
now where is the representation submitted by you?
Lordship.
Where is the representation submitted by you?
That is not mentioned, Lordship. Already he had forgotten, but I have mentioned the representation.
What do you mean? You have stated that is not.
Paragraph 7, Lordship, kindly see, Lordship. Read.
No, where is the representation? You said that you have submitted representation before the department
Yes,
for
Lordship.
consideration of your case. Where is that representation?
Transport Department, Lordship. Transport Department.
Okay, transport department, but where is representation submitted before the transport department?
Director, Lordship. Director, General Manager, Lordship. Transport, State Transport Service now.
Okay, that I understood.
Lordship.
But where is the representation submitted by you before the state transport service? You say that you have submitted representation where, for consideration of your case while
Lordship.
you were still in service.
Lordship. That is the problem, Lordship. Accordingly, I have the paragraph 7, Lordship. Annex of 5 is the refixation of the.
Yes. Yes.
Your Worship, notice may be issued.
Notice. Okay, only issue notice. You file affidavit. If he is entitled, I think if the similarly situated person, he was a regular,
Yes, Lord, regular employee, Lordship.
then he is entitled. Why not given?
I'll take instruction. of-
Then instruction and file the affidavit form straight away.
Yes, sir.
But Mr.
PK Gogoi, Lordship. But my name is not shown. I have signed in Ugala Nama, Lordship.
P.K.
Gogoi.
Gogoi, land counsel for the petitioner. pensionary benefits as per the refixation of pay under the 6 and 7 Central Pay Commission. However, he was not given. Therefore, seek direction for refixation of his salary as per the 6 and 7 Central Pay Commission and to release his arrear salary as per the refixation. Under 6 and 7 pay, the Central Pay Commission. Start. Issue notice. Returnable within 4 weeks. Start. Ms. Sangita. P. Sangita, Learned Government Advocate, accepts notice on behalf of the paid respondent number,
1260, Your Worship.
all
Yes, Your Worship.
the statement, respondent number 126. No formal notice need be issued to the respondents. However, the petitioner shall furnish requisite extra copies to the land government advocates during the course of the meetings. List this matter after 4 weeks. Okay,
Lordship, kindly maybe give maybe fixed Lordship.
that,
Yes, Lordship.
then,
Your Worship, 4 weeks.
First week of September, Lordship.
okay. Then, age grateful, list this matter again on 11 August. Okay,
Lordship.
11 August, Your Worship.
11 August.
Okay.
Did decide for
11 August, Lordships, already not completed 4 weeks, Lords.
okay, then when?
September, Lordship.
18 August? September, okay, 8 September,
Lordship.
okay, 8 September,
Highly read,
Okay.
Lordship.
yes.
My lordship.
Yes,
Lordship, petitioner herein is a teacher, postgraduate teacher geography. Now he has been transferred from his current posting place to Siomi district, Mechuka. Lordship. My lordship, the case of the petitioner is that the petitioner was last transferred from Kamba, Government Higher Secondary Kamba to Alo on 16/8/2023. Now, and he has served only 1 year, 9 months, and 18 days at present posting place, Lordship. Lordship, last posting order is at page number 20, Lordship. My name is placed at serial number 5.
yes.
And joining letter at page number 22, Lordship.
Yes,
Page number 22 is my joining letter.
this is the last transfer.
Last transfer order.
Okay.
And now, Lordship, the impugned transfer order is at page number 23.
23.
My name is placed at serial number 6, Lordship. Now, Lordship, as
Your
per
name is serial number?
serial number 6, Lordship.
Okay.
Now, as per notification dated 19 June 2025 issued by the Department of Education, the normal tenure for transfer and posting is 3 years, Lordship. Now, page number 27, Lordship. general guidelines for transfer, Lordship. 10 of subclause 3, Lordship. My Lordship. And Lordship, as per Rule 14 of the notification, this notification, I have submitted the representation before competent authority, Lordship. My representation is placed at page number 44, Lordship.
What the rule 14 says,
Rule 14,
if any grievance.
grievances redressal, Lordship.
Okay, you have submitted representation.
Yes, representation, page number 44, Lordship.
Okay. Stating what ground?
Setting medical health ground. Lordship may kindly come to the page number 49. Now the respondent authorities have
What is this page 45?
page number 49, Lordship.
Now, what is this page 45?
Now, here in
What
page
is
number
it?
45, the principal government higher secondary school, ALO, have clearly stated that my name is at page, serial number 5, Lordship.
Page?
Page 49. Serial number 5, Lordship. And remark column, Lordship. Reliever joined in retention on request of so and so, and representation of incumbent on medical ground and incomplete tenure of service period at present posting place, Lordship. This is the remark made by the principal of that particular school, Lordship.
So this is what is this? This letter is to the Director of Secondary Education. Who wrote this?
Principal Government Higher Secondary School, ALO, Lordship. Page number 52
To the
is
Director of Secondary School.
yes.
What letter is this? Letter communicating?
Yes, this is official correspondence letter, Lordship, wherein my
Communication on what for?
in pursuance to the impugn transfer order, Lordship. And now subsequently,
No, this is in response to your representation or just it is initiated from the office itself?
yes, that is not my case, Lordship. My case is on at page number 45.
Regarding release, retention, transfer, teachers.
Now here, why I am submitting this before Lordship is that here my case is clearly indicated that I have been retained for representation of medical ground and the non-completion of the normal tenure, Lordship.
Just a minute. This is all with the PGT of the same school, all the 5. Where is the second page of this?
Page number 40,
Letter? After
52,
49.
52.
52?
Yes, Lordship.
What is 50, 51?
The page number 50 and 51 is the type copy of this page
Okay.
number 49, Lordship. By this letter, my representation has been forwarded to the competent authority for consideration, Lordship.
Your name is
Yes, Lordship.
Yes,
And Lordship may kindly come to the page number 45, Lordship.
page 45.
45, Lordship.
Okay. What is that?
This is Constitution of Medical Examination Board, Lordship.
This is who directed for?
Director,
Hmm?
Director, Lordship.
Director.
Lordship,
director.
as per my representation, my case has been referred to the medical board for examination, Lordship. And page number 46,
Just a
my-
minute, sir. Just a minute. Okay. 46 is
46, my name is placed at serial number 1, Lordship.
serial number 1.
1, Lordship.
Okay. What is this? Please.
This is list of the teacher who has seeking retention for on medical grounds.
Who is? Huh?
Seeking retention on medical grounds.
Okay.
Continuation of page number 45.
Okay.
And so my case is recommended for consideration by the medical board, Lordship. Now, Lordship, subsequently, during pendency of this, the petitioner has been released. On 15th of this month, Lordship.
Okay. That
After knowing the fact that my case has been referred to the medical board for examination. Lordship. Now, my respectful prayer before this honorable court is that when my case is for consideration by the medical, this release order may kindly be suspended till the outcome of medical.
no, already released.
Yes.
This already, reliever has also joined, madam.
Reliever already joined.
Already joined.
Yes, Lordship, that is my case. When my case is already referred to the medical board for examination, considering the merit of the case, Lordship, I have annexed my medical document.
My lord, may I suggest, my lord?
Yes, please.
My lord, one thing, his representation dated 9 June 2025 at page 44, my lord. It seems that his representation is being considered, man. Is under consideration, man. That's why, pursuant to his representation, the authority has requested for constitution of medical board, man. Since his representation is under consideration, at best, his representation may be disposed of, may be directed to dispose of, because this has been released and reliever has already joined. In case if the government modified automatically, if he is found his medical ground, if found to be genuine, authority may modify the order, madam, instead of disposal. That will be better, I think.
We'll give that direction then.
Yes,
To
till
dispose
such
of your
till
representation because
yes,
it's
Lordship.
consideration as per you.
Yes, Lord. Till such period, the petitioner may not be initiate any coercive action for not joining the.
Already released.
Yes, Lordship, that is there.
Status quo.
Status
at
quo
best,
maybe.
at best, it may be.
In the meantime, status quo.
Yes, Lord.
Status quo means release only.
Yes, release Lordship, but
Okay. Mr. K. What's Aringo, Learning Council for the petition. I've also heard Mr. T. Tobin, Learning Standing Council for Education Department. Okay, I'll dispose with that, huh?
Lordship, at least I may not be, the petitioner may not be initiate any coercive action till during pendency of this medical board.
There is no scope of taking any coercive action against him. Already released, he's nothing.
Lordship, that is there, but for non-joining of the petitioner to the current posting place. Lordship.
Authority will consider this.
Since the petitioner is undergoing medical treatment, here it under itself, Lordship. So the joining in this hour is not possible for him, Lordship. At least that observation may kindly be, Lordship.
Just a
Authorities
minute, can I
are-
take the, yes. Perfect, where is your,
Page 44 is representation.
all medical related documents at page number 35 to page number
Okay.
45, Lordship.
Let me go.
Now I have undergoing
Just a
me-
minute. You dispose of the representation within 3 weeks,
my lord.
okay?
Authority will consider is already under active consultation.
Yes, Lordship, that is there. If, but if I am not joined, there is probable the
No,
probability of taking
joining
action.
is up to you.
Lordship, I am here in Itanagar also.
We can do, otherwise his payment and
Yes,
salary, that will be a problem. There will be.
You will face problem otherwise.
No, no, at least, Lordship, I may not be initiate any coercive action for not joining the present posting place till the outcome of medical examination, Lordship. That may be. Otherwise, I would have joined earlier if my health is problem. Deeply aware.
Huh? With that direction, okay.
Deeply aware.
Yes,
Lordship, in this petition, I have a very limited Lordship. Lordship, the land of the petitioner has been acquired for construction of Tato to Monigaon intermediate road. However, Lordship, after preparation of personal award letter, individual award, under section 37(2) of Act 2013, the respondent authority, they are reluctant to provide the final bill. And the,
award,
yes, award letter, Lordship.
awarded,
Yes.
you are not satisfied with it.
Yes, Lordship. Even I cannot say that I am not satisfied with, but since I have not been made available copy of that award letter, Lordship.
If you are satisfied, then what that will do?
Lordship, I have been provided with one single copy, Lordship, but that is not covered any details, Lordship.
Are you satisfied with the compensation?
No, Lordship, I am not
received by you?
satisfied with.
Why not?
Lordship, I have a
And making it a commercial.
yes, Lordship. My livelihood is completely dependent on that land, Lordship.
So, what do you want then? What is your prayer?
A re-verification and resurvey, Lordship, and prepare the award
Already
letter.
verified
Yes, Lordship.
and then compensation determined. Already released also?
No, Lordship, that is not true.
Not yet.
I did not
But
receive,
the
Lordship.
amount has been.
Yes,
Okay,
I did not receive.
not received.
Yes.
It is to be paid by through.
To
account.
Deputy Commissioner, Lordship.
Okay.
Award
Your-
letter,
Your only grievance is to re-verify,
yes,
as you are not, have not been given copy.
yes. And my all the properties should be verified and calculated as per the Act, Section 26 of the Act.
How do you know that it was not calculated as per the section, as per the rules?
Lordship, for that, I have already applied for RTI, Lordship, but that RTI is yet to be disposed. And even I did not provide any details regarding the acquisition of my land. I have approached several times by submitting by way of representation, Lordship. But that representation also pending before.
Land was acquired or not acquired?
Acquired, Lordship. Some of the landowners, they have get their,
Then in respect of your land.
yes, already acquired, Lordship. Now, Lordship, may kindly come to
That
page number
acquisition-
40.
that acquisition, those papers are with you?
Yes, Lordship, page number 25.
Okay,
Lordship.
then your grievance now is with regards to the compensation only.
Yes, compensation only.
You are not satisfied.
This page, Lordship. Page number 25 and 26.
Hmm?
Page number 25 and 26. Lordship.
What is this?
This is the award, individual award
Yes.
My lord, this writ petition.
Are they entitled for all those information?
Yes, my lord.
Okay,
My,
let's-
I'll satisfy my lord. Page 25 itself.
Yes.
What the case of the petitioner is that there is no mention of land area, name, everything. My lord will kindly see the notice itself. What it says. I'll read from the second para.
Hmm.
Take notice that you are assessed as project affected family beneficiary of the land which is being acquired for the above mentioned project under section 23 and 30 of the Lara Act. Your award has been prepared by award number so and so dated 29/5/25. My lord, and on presentation of necessary documents, you shall be paid a sum of rupees so and so, so and so. You may inspect the award on 10/6/25
Hmm.
at the of the undersigned.
Yes.
Because the details of the award is in the office, the
Hmm.
individual description, detailed description of the award, how it has been calculated, what is the properties. If you accept the above compensation assessed in respect of you, then either by yourself or your authorized representative may appear before the undersigned on any working day on or after 10/6/25 and present your necessary documents detail of bank account so and so, so and so.
Hmm. Yes. It's clear.
Now, even before going, he submits. Before what his on 9 June.
Hmm.
10 June is, you may inspect the award on 10 June 25. And representation is
9
at page 9 June.
Hmm.
He totally misconceived. Go to the office, you'll find your detailed award.
Immediately on the next page.
No, my lord.
No, see, he has submitted representation on 9th.
9.
This award was
He-
presented on
One
29th.
day left for his
Yes,
inspection.
yes. One day left. On 10th, he should have gone to inspect.
Yes.
10 at, you may inspect on 10th so at the office of the undersigned.
Yes. Yes.
Even prior to going,
Hmm.
date of inspection,
Mhm. So,
he in the air claims that her property has not been assessed, nothing, she is not.
no, you cannot. So now you have seen this probably due to.
Lordship may kindly come to page number 34.
And my lord,
Just a minute.
further, my lord,
Hmm.
if he is not satisfied
Hmm.
with the award
Hmm.
under the Lara Act, there is a provision for reference, section 64. If he is not satisfied with the quantum of the compensation
Hmm.
or the apportionment, anything, section 65 of the Lara Act
Hmm.
will apply. How this court will entertain? Section 64 of the Lara Act. If he is not satisfied, Section 64, any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred to by the collector for the determination of the authority, as the case may be, whether his objection be to the measurement of the land, the amount of compensation, the person to whom it is payable, the rights of rehabilitation and resettlement under chapter 5 and 6, or the apportionment of the compensation amongst the person interested. The deputy commissioner is the collector. The authority will be civil judge. The district judge has been designated as the authority who will decide when the reference is sent to the
Hereafter only you could visit. Yes, now you have seen.
No, Lordship, that is there, but Lordship, section 37 subclause 3 of the Act. Lordship, may kindly. Lordship, may Lordship.
37. Yes.
The collector shall keep open to the public and display a summary of the entire proceeding undertaken in a case of acquisition of
Which
land.
you are reading 37.
37 subclause 3, Lordship.
Close to it. Okay.
Yes.
Yes.
The collector shall keep open to the public and display a summary of the entire proceeding undertaken in a case of acquisition of land, including the amount of compensation awarded to the individual along with details of the land finally acquired under this act on the website created for this purpose.
Okay.
Lordship, what is happening in around Arunachal, Lordship is well aware of the fact that Lordship nowadays the district authorities, they are very much reluctant to provide the copies of final award to the affected beneficiaries. I have on several occasions, I have approached before the deputy collector, even the government, and they are reluctant to provide the copies. And now, just prior report to the disbursement of the amount, this notice has only been issued to me. Now, I have not been given an opportunity to inspect, to raise any objection as to how my compensation, how my land, how my property has been assessed.
No, after 10.
So, without knowing the details,
No, after 10, have you visited the office?
Lordship, there is no office there at Tato.
Land Acquisition Authority.
Now all the staff of the land department, they came there at Alo in a hotel room. Lordship. And these petitioners, they are villagers from Karo, Lordship, where there is no proper communication.
Has it
Lordship.
been made available on the website?
And when they approach before this hotel room, sometimes
Listen, has it not been made available in website? created
no,
by-
Lordship, not even not in website, Lordship.
So
Not
no
only this project, all
No,
the projects.
specific query. After 10, have you tried to visit?
Lordship, I have visited several times, but there is no office system. Only
Your
beyond.
representation is on 9th only.
Yes, Lordship.
This has to be after 10.
After this representation, I have already again visited there at there on 18th, Lordship. Page number 35. All the project taken up by this project proponents in the district, same condition, same situation, Lordship.
Page-
So many cases are pending before this honorable court, Lordship.
Page number
Page number 35, Lordship.
35 is second page of 34.
Or 34 and 35, Lordship.
Okay.
36, Lordship.
Compensation. This was 18.6. Let us see what is the contention.
I have given my details of properties, Lordship.
First stage listed items are missing.
I have this much of properties Lordship, in over my land. And these properties are being properly calculated. If properly calculated, the amount which they have provided is much lesser.
Mr. Additional AG, it appears that after tent also on this,
Yes,
she has made this. And probably that is after perusing the record, it appears that these things are not been included, 25 items.
first of all, my lord,
Hmm.
when the inspection is to be done,
Hmm.
the inspection of award, what I have been told that a copy is given that this is your award.
Hmm.
A copy is written in the office.
Hmm.
One copy is given to the award.
Hmm.
Thereafter, if yes, if there is lacuna, something missing out, he can make this complaint that I'm,
No, sir.
yes, he can make the complaint that these properties have not been included. This is okay. Okay. That will be determined by the collector whether this has been left out or not. This will
Okay,
be,
again, after this,
yes, this will be re-verified whether this has been left out or not. It will be re-verified if his claim is genuine.
Okay.
That
the procedure is that after tent, so okay, then there is a stage that this will be disposed of by the deputy commissioner.
yes,
Okay, so that
That-
has not yet come.
that has not yet come.
Hmm.
This was submitted on 18/6.
Hmm. Then in that case, it is under process only, it appears, because the procedure, as per the procedure, that was on 9th. Forget about 9th.
Yes,
So
sir.
after that, after 10, you have visited and you found that these things are missing and you have put forward your grievances, and this will be considered by
Lordship,
by the deputy
Lordship,
commissioner.
today is 22nd, Lordship.
Yes.
1 month and 4 days has already been lapsed. Lordship, lapsed. I have submitted this application on
Is there any
in the month of
Wait.
month of June. I have submitted. Now today is month of July, Lordship. Even after 1 month,
no, how within how many days the deputy commissioner is to consider these grievances after, because this is probably the protest.
Lordship,
Question of the
in
missing
protest,
items.
there are 1 month time.
Hmm?
If I go to the reference code, that is the deputy commissioner has to comply and has to file the report within 1 month, Lordship.
Where is it?
Section 67.
That reference will be sent within 1 month by the deputy commissioner.
Within 1 month.
Yes,
So that means,
that
so that is 18 July.
reference will be sent.
22nd July. This
And you
represented
also instruction that whether
Yes.
on this representation regarding pointing out the missing items. Still pending before the deputy commissioner. He is yet to dispose of this.
Yes, Lordship, but
Re-verify. After re-verification, if it has.
If he asks for reference,
Hmm.
no,
reference.
Lordship, I am not asking for a reference. I am before this honorable court for issuing direction to deputy commissioner for inclusion either re-verification, resurvey of my property
No,
loss.
this pointed out as per the rules, then he is bound to resurvey, re-verify.
He is bound
Because he has
to
pointed out that these
not been included.
items has not been
Yes.
included. So we are bound to re-verify.
Yes, but whether this has been has been mentioned after inspecting the detail of the assessment or not.
No,
That itself is not clear.
After notice, this is after notice. The
Yes, my lord,
notice.
but he has
In the
not
notice,
said.
we have clearly said that, then at the office of the undersigned, okay? And if you accept above so and so, and you authorize the representative may appear before the undersigned and acknowledge so and so and present so and so.
You may inspect the award
If-
on so and so at the office of the undersigned.
Hmm.
That on 10/6. Now,
So
what
now,
his,
now she has. She,
In page 34
raised her grievance saying that she is not accepting because these things have not been
my lord,
included.
here what the language is,
Hmm.
it has come to know. It is not that after inspection,
No, which one you are reading?
page 34,
Okay,
reference to subject item, it has come to know that previous approved compensation items
it
against,
is come, okay, it is come to know, not.
yeah, Srimati so and so, so and so, so and so, it has come. Statement in the petition saying that I have inspected and after the inspection, these items were missing.
No, it says that final. She says that final stage listed items
Yes.
are missing. Not listed in final bill list. So these things are not being listed. So if it is not listed, then it was not included for the purpose of compensation. Calculated for the purpose of compensation, it appears. Then what to do? So this.
Lordship,
Hmm.
Lordship,
Paragraph 9 of the writ petition, my lord, will kindly say, it is there is no statement that he has visited and these items are missing. Paragraph 9.
Now, but the application
Yeah.
says.
It is further begs to submit that due to non-availability or non-furnishing of final bills to the project affected families, the petitioner could not file even reference application before.
No, not yet filed. Could not file reference.
Yeah.
no, Lordship, I did not file any reference application.
see,
Because
what is this?
what is the reason? Due to non-furnishing of final bills. What is the direction in the notice that you go and inspect on 10? He never goes there. Even prior to the date of inspection, he makes a representation saying that these are not done. Thereafter, makes a,
No, you yourself said reference application could not file. Yes,
Lordship, which I have and which is attached to my land. Lordship.
Hmm.
An other person having lesser amount of land and properties are getting more amount. Lordship, that I can prove, Lordship, in later stage. There are 4 or 5 projects going on at
That
there.
appears then, if it is not the reference, you yourself said you could not file reference. Yes, it was not seen. You probably have to go to visit the office.
first obtain
Hmm.
that compensation. If
Yes.
he is not satisfied,
Hmm.
then he can either make a request for resurvey to include these items if it is not included. And if the quantum is less, he can go for reference.
Lordship, here in the petitioner's case, petitioner is fair enough that unless her property is properly assessed, he will not receive the amount. Maybe property is less.
You see the award, go and obtain the award. Award is, if you inspect, you will be provided with a copy of your award.
Yes, the.
Lordship,
page
where are
30
not
page 34, just a minute.
where is who
This
pinches,
page
Lordship?
34 is not a reference, not a reference.
Yes.
So this sounds like a reference, but it's not a reference. Hmm?
Yes.
So you need to file reference.
Lordship,
Immediately.
authorities of the land department, they are sitting in the ALO and making their own bill.
that is why, that is why.
Where,
you
where,
have to visit-
where
you have to
I
visit.
should go, Lordship?
You have to visit.
I have
each-
filed the presentation report to competent authority,
see
Lordship.
the record.
And what make them
copy.
to, what precedent them to resurvey and re-verify my property, Lordship?
You make a reference, then they will survey, isn't it?
There is no website created, but what is being provided is you can obtain it from the office respective
The rule,
award.
if the rule
That
says
is
that-
statutory
Yes.
provision of that.
if the
if-
rule says.
yes,
it
rule-
is available in the website.
Yes. Created for the
Why?
collector's office.
There is a provision.
On website created for this purpose. If the website is not created,
You have to create.
yes, that has to be created. But for this particular case, how does the petitioner be aggrieved whether it's published or not?
Because-
Now, if
No.
he is being given notice that you may come and get your
Now,
details from the office, that he doesn't know, and he doesn't know how it has been calculated in the air.
now probably you need to obtain instruction because according to him, he expressed the difficulties that the office is not there at Tato. It is at Alo, they are staying in
This
the
is-
hotel,
this
which
is
is
a
difficult for the lady especially.
This
To
is
find
a-
out, especially for the villagers, to find out where the location is. So we either create this, as per if the rule provides, you have to create a website. And then this copy, you have to give the proper address and then so that we see or obtain copies or see the records.
My lord,
Facilitate that. And then we can go for.
yes,
see.
my lord, in that event, notice may be issued. What are the procedures will come in affidavit.
Okay.
If there is no website created, notice may be issued.
Okay.
Will come with detailed affidavit.
Okay, Miss Haring, Planning Council for the petition. The by filing this petition under Article 226 of the Constitution of India, the petition direction to the respondent authority to conduct re-survey, re-verification of their lands and properties for preparation of award, final bill with regard to payment of land compensation for construction of 53.40 kilometers intermediate road from Tato to Monigong, Shiyomi district, Arunachal Pradesh, undertaken by NHIDCL. Start. It is submitted that the petitioner is in possession of approximately 30 acres of agriculture land at Karo village under PD circle of Shiyomi district, out of which 12 acres of land, approximately, including the standing crops and properties, are going to be affected by the construction of aforesaid road project. Start. are not included in the fine award bill for payment of land compensation. Therefore, seek direction to the hence this petition seeking direction for inclusion of the property, seeking direction for resurvey, re-verification of the land and properties, and for preparation of the award final bill. Okay, issue notice. Since Mr. N. Ratan, Learned Additional AG, has appeared and accepted notice on behalf of the all the state respondent. No, yes.
No.
we-
1 to
somebody else.
1 to 5.
Respondent number 1 to
1 to 5.
respondent number 1 to 5. No formal notice need be issued to the said respondent. You are appearing, okay. NHI
6 and 7.
6 and 7. Okay, Mr. M. Kato. Planet 10. Planet S. DSTI. For the respondent number 6 and 7. No formal notice need be issued to the said respondents after vote. But however, the petitioner shall furnish requisite copy. The number 8 and 9 by a registered post with AD, as well as by usual process within a week from today. Start. List is matter after 4 weeks.
Lordship, since construction is going on, till
But
reasonable
that-
that my land,
No,
You
my
are
land,
seeking-
madam.
you are seeking
Otherwise, Lordship,
copy.
re-verification would.
my lord, how can he,
No, at least my property should not be disturbed.
how can he?
Unless
solve that?
re-verification is conducted, Lordship.
This writ petition
After-
itself is not
After construction
mentionable.
of project, how re-verification can be carried
The
out?
construction is going on now.
Yes, Lordship.
Writ petition
In your
itself is
lane
not
also?
mentionable.
Yes, Lordship. The
Your
construction
lane
is going on, Lordship. But not in my land, Lordship. From the-
The construction would be little difficult.
Stopping them for.
No, I am not
developmental
seeking for the stoppage, Lordship. At least unless my property is protected. Even
my
if
lord,
the
already
letter is said, if
if
the
he
resurvey
visit-
carried out, how my properties would be calculated, Lordship?
If he
Without
visits the
physical
office,
presence of
as per
property.
the notice and finds out the details, first he has to find out the details. He has not even visited as per the notice. In the air, he is claiming that this is not included, this is not included. This is not maintainable.
The petitioner has submitted representation before the Deputy Commissioner C. Yomi Tato on 18/6/2025. Sorry, come, stop. There shall be no bar
Yes, to consider the
to
representation.
consider the said representation during the pendant, during
Yes,
the consider the on the part of the Deputy Commissioner during the pendency of this writ petition. Okay,
Before
initiation
initiating
of the missing items, if any.
if any, missing items, comma, if any.
before initiating construction
My,
activities
no,
in my-
no,
over my
no,
land.
that,
Otherwise,
those,
Lordship, after construction, how my land and properties would be calculated?
my
Lordship?
lord, this writ petition
Now your
itself is.
claim remains because it is after, before the construction started, you have made a claim. It will be treated that it was there and make it clear.
Otherwise, Lordship,
Taking photograph,
otherwise,
whatever
Lordship,
may be, video,
My lord,
whatever may be.
Developmental works cannot be stalled
Because now
for this.
you have not yet denied. Unless it is denied, it will be treated as it was there.
My lord,
in
therefore,
the name
the
of
details
development,
could,
my
details
properties cannot
could have
be-
been obtained by him.
So
if
by
he has not-
denying these claims, you have to dispose of
Yes, yes.
representation immediately.
Otherwise,
This has to go to respondent 8 and 9 also.
Hmm?
Notice has to go to respondent 8 and 9
No,
also.
that is why. Notice here we will take steps.
Yes.
Otherwise, Lordship, my this representation may be disposed of within a specific time. Your Lordship. That would be suffice my prayer, Lordship.
Then, instead of no bar, the Deputy Commissioner of this, the petitioner has submitted this representation on 18, claiming so and so. The said representation shall be disposed of till the, disposed of within 4 weeks before the next date, okay? 4 weeks, and place the,
It's a
within
first
4
report.
weeks, and 4 weeks with, 4 weeks, stop, and place the same on the next date, okay?
Yes, yes.
That, yes.
Diplomat.
Notice has to,
Yes, 8 and 9 also.
8 and 9.
Shall obtain certified copy of this order and submit it before the Deputy Commissioner. Deputy Commissioner, okay? So the Deputy Commissioner will be 4 weeks. Okay, yes.
May I plead your lordship?
Yes,
Well, my matter is a transfer matter. Basically, the petitioner is working as a child development officer right now at Kanubari. Well, especially in this writ petition, we are seeking only the for retention of the petition in the same posting place on the ground of the medical. Basically, we are not seeking on the medical. I'll just take to the impugn order. Your lordship may see the impugn order in page 13 and 14. 13 and 14.
yes.
13 is the 14 is a type copy. May I just read that the partial modification of government order that is such and such, that is 6/1/2025. There was an earlier transfer order. The government of Arunachal Pradesh is pleased to order transfer and posting of such and such individually to Kanubari CDS project with immediate effect. Consequent upon transfer of Srimati such and such to Kanubari CS project, the government of Arunachal is pleased to order the transfer. That last paragraph, that's last line. Order to transfer and posting of Srimati Sachitra Lego CDPO Kanubari project to KIPPI CDS project with immediate effect. So so KIPPI is around 665 kilometers from Longding, from the present posting place. So, my lord, may I just take to the earlier transfer order? Earlier transfer order, may allow me see the para 15 and 16. 15 and 16. Second column. Such and such the petitioner, CDPO Palin, is transferred to Kanubari ICDS project. So basically, this order was we have annexed the medical report. That's it. Basically, I'll just take to the page 25. Page 25, where it is mentioned the name of the disease. Page 25. Page 25.
What is this?
Basically, it is doctor has issued. So I will just read the name of the diagnosis. May read
No, we don't.
Third line. Married. Investigate. She was diagnosed as a pyelonephritis with AKI. AKI. She was admitted under Department of Sciences and was shot with the respective department after the proper evaluation and treatment.
What is your prayer?
So she is still she is still in the medical leave. The medical leave is still from 1st July to 30th July.
Where
She is-
do we find that?
Uh,
Granting of leave?
grant of leave. In fact, we have not next document, but your lordship may see my paragraph. I have made abandonment in my paragraph. Okay, I will just show you the medical report. May see how she has been treated. I will just take to the medical report. Page 19. Page
The
19.
medical report was okay. It's okay. We don't understand.
I will just only reflect the date. Only date. 01/07/2025. That top right. Top right. And then that is 1/7/2025. And then I'll just take to another date. Messi in page 23. Page 23, right top. The date is
Yes,
3 July.
Why you have been transferred?
Transfer, in fact, I have
Yes,
asked for the medical
yes.
on that ground only.
Okay.
Madam Lordship.
Oh, so she was transferred and when just 1 year and 1 month.
No, no.
No, that is earlier transfer.
Earlier transfer.
Earlier.
Here, she has already completed more than 2
Here,
years.
she has
Where
completed
more than?
2 years.
2 years. That is no.
Your last transfer order is of January 2023. And
No,
she joined in the
25.
month of May.
Okay, it's not 24.
No, I'm not disputing that one, my lord. It's
Yes.
more than
And she joined in the month of May
more than
May.
2023.
So 2 years, 1 month.
2 years.
yes,
2 years,
2 years.
May, 2 years more than
Yes, yes.
2 years, 2 months she has completed.
Hmm.
So basically, transfer matter loss.
Hmm.
Court lawsuit is transfer matter basically court lawsuit does not interfere.
Yes, yes.
Until unless lawsuit any right is violated,
Yes.
any rule is violated. If lawsuit see this present writ petition, what rights of the petitioner has been violated? Number one, there's no guidelines has been violated, no rule has been violated. This is more like a mercy petition only lawsuit.
Yes, ma'am.
Here lawsuit,
Of-
only the
on
medical
on
ground.
medical ground.
The hardship, the subject of hardship issue is to be lawsuit considered by the authority only lawsuit.
Yes.
This completely purely the issue to be determined and considered by the transferring authority.
You submitted representation.
Yes, my lord.
And that also has not been annexed here.
In fact, that's inadvertently we have missed an act. I will just give the. Sorry.
The statement is here in paragraph 7,
But
it has not been annexed.
statement, it will collaborate with the statement, your lordship.
Even then, lawsuit, this writ petition can be disposed of with direction to the authority to consider. That we do not know because this the impure order is of
It
June.
is statement only, of course.
No, I have
Already more than a month has already passed.
But,
No,
but,
it's-
but she is still on leave as per the.
Only,
statement.
yes,
If
yes.
other one has already joined lawsuit, we do not know.
No, that's not. They have. That's what I'm seeking the status quo, your lordship.
Lawsuit may.
They have not joined.
Lawsuit may say that if she has not been already released or
Okay.
the new incumbent has not joined. In that case, lawsuit.
No,
With that objection, lawsuit.
That observation can be made if not released, status quo.
yes. Yes, yes. No,
Or
in fact, we have
status-
mentioned in
Status
the.
quo is on that.
Yes, no.
Lawsuit, lawsuit may if the new incumbent was. One the respondent
Yes.
is already there, lawsuit.
Yes,
If
yes.
she has not already joined lawsuit.
Hmm.
If she has already joined lawsuit, 2 officers would be there in the same post. How the salary would be
No.
prepared lawsuit. That issue will come lawsuit.
Well, we have.
And here lawsuit, he is supposed to lawsuit states the status of the case lawsuit. in the read petition itself also.
My-
Whether she has joined or not, all these are not stated in this.
No,
read petition.
no, I have studied the paras.
Submitted or not yet? Or
We have submitted. Your Lordship.
Submitted.
Yes, Your
So
Lordship.
no need to submit a fresh representation.
Fresh, no issue.
Required. Only to dispose of this.
Yeah, only this. We can submit the update medical report also. Your Lordship, if we allow. Madam, may I see the para 7, we have categorically stated that she has not been released and her medical leave is till 30 July and she has not joined back.
No, I am not. Whether she has joined or not, new incumbent.
Okay.
Let us go
Yes.
agenda.
No issue, no issue, Your Lordship, no issue.
And moreover, one more aspect also. Where she has been transferred also. That also is not clear also exactly. One
No,
KIDP project, but where it's situated.
Hmm.
We don't know now. Nothing, no statement has been given in that aspect also.
No, it is in the transfer order. No transfer order. It's a KIT P.
Transfer order, that probably is not clear,
Ah.
but then they would know.
The area is not, the project is there also, KIDP project, CDS
Hmm.
project, but
So
where
this-
it is also.
But KIT P,
That you have to clarify.
KIT P, we have confirmed that it's in Tawang, Your Lordship. We have confirmed that it's in Tawang. I think department, I
Okay.
think he
So,
should know better than us.
Direction to dispose of your representation considering your health condition, present health condition, okay?
Yes.
And you file fresh representation.
We also filed.
Yes, it's
And it will be there. In the meantime, if the respondent, the reliever has not yet joined in the place of, in place of the petitioner, then in that case, status quo as on that shall be maintained.
Yes,
Okay?
yes.
Lordship, one more prayer also, time frame may be given. Since Lordship,
Time would be, so
Lordship is giving liberty.
dispose of within 30 days.
no, 10 days.
Okay, 10 days.
And the petitioner has to file, if
Within-
he
within-
want to file within 2 days. This is at
She's-
Itanagar only.
It's it, and
See, at Itanagar only.
but
Now,
she
you
was
file-
there.
You file within this week.
Within 2 days, Lordship.
No, at least
And in
15
another-
days. We have
Another
to.
10 days, it will
Okay,
consider.
another 10 days for consideration of the disposal of the representation, okay? You file within this.
But at least 15
left
days.
3 days, 3 more days.
Lost,
left. Okay,
lost.
within this week, okay?
No issue.
Okay, disposal, this will be.
Obliged.
Have Mr. Sunil Mohan, Land Council for the petition. I will have Mr. Tapin, then Sunil Mohan advocate. Before the respondent, state respondent. Okay.
All right.
Yes,
Madam, here the permission holder, petition is the permission holder to carry weekly market at the Iskami district Sekpa, Arunachal Pradesh.
yes, sir.
Your Honor, that petitioner has put to challenge the action of the respondent number 4, that is Deputy Commissioner Iskami district, Arunachal Pradesh. Kindly, may your lordship see the page number 32 of my petition.
Just a minute, sir.
This is the impugn order by the Deputy Commissioner Iskami district.
Okay.
Whereby,
Weekly market.
yes, Your Honor, whereby entire weekly market that has been
That
operated.
is because of the reason that it's a government decision only. What can we do?
Yes, Your Honor. That is, can you see the page 37 of the petition.
Hmm?
This decision was taken by the state government in the wake of the terrorist attack at Pahalgam, Kashmir.
Yeah.
And now there is no more threat. And
You
this
make a
same-
representation before the authority then.
we have filed.
You
Your
have
Honor,
filed?
yes. Same petition is pending before this honorable court. Wherever this honorable court has stayed the impugned order of the Deputy Commissioner, Your Honor, of this UPR, Papampara district. Same nature case, Your Honor.
I have no idea. Have you annexed?
Annexure is not met in, but in my petition I have mentioned, and the WPC
Then how do-
234,
How do we know?
that read petition number 234 of 25. In that
You have not
yes,
annexed.
that order copy is not annexed here.
Why? If some documents or on order, you should have annexed.
Yes, Your Honor.
Forget about that. Submit your case.
I think, Your Honor, that the this action of the state respondent number 4, that is completely violation to the right of the petitioner. Even I have not received any notice also, Your Honor, in this case, that the principle of
See, it's a decision of the government, it appears, minute of meetings. You have challenged the minute of meetings.
Your Honor, here it is also
See,
challenged.
the Honorable Home Minister.
Yes, Your Honor. And it
And
was only minutes of
It's
meeting.
a decision, government's decision only,
Your
taking
Honor,
into account of the security.
it was
And see, and then there was it appears that see, there is a complaint against the market also. Case against individual indulging gambling activities in the weekly market.
Your Honor, for that reason, Your Honor, in
All those. And then the weekly market has failed to adhere into with the orders and terms and conditions.
there is a terms and condition while granting that the permission to the permission holder, Your Honor.
This has been
And
decided for the
some of
safeguard of
12
public
rupees.
security. This is safeguard of the public security and to maintain law and order. So that, and as well as to curb the menace of drug abuse and prohibit gambling within the district. So that, can we interfere with?
Yes, Your Honor. The state respondent number 2, that is the Home Department. The meeting was conducted on 30 April 2025, and very next day, this suspending order
Okay, let us see, where is your representation?
representation.
Yes, against.
Representation,
against-
I have submitted before Deputy Commissioner on
Where is that?
page number 39 and page number 41. 2 representation we have submitted, Your Honor.
True representation.
Yes, Your Honor.
It has not been disposed of.
No, Your Honor. On 12 5 we have submitted I have submitted again on 25 June 2025. Again, I have
So
submitted.
this was on 12 June.
And in page number 41, this was submitted on 25 June. Your
25
Honor,
June.
yes, I have been paying the renewable fees to the state. And also I have created a lot of structure at Weekly Market, and more than 80 vendors who have been depending their life on that.
The notification
Vendor.
is for entire state.
Yes, Your Honor.
Okay.
That
That is.
notification
decision of
was
the government.
issued for
Okay,
intent.
anyway, yes. So, yes,
Lordship, in other
Yes.
other orders, there is the word cancellation. Here,
suspension.
only suspend. Lordship.
So he is in
And
a,
then,
he is
yes.
in a better position.
Yes,
So disposal of the representation would solve the problem.
yes, that much only.
then we can
Otherwise,
direct-
Lordship, there is nothing to interfere because
Because you-
it's
you're-
already in the order that
Yes, according
this
to
is
you.
in view of the public security, and we,
Yes, yes.
since
That
in
is
these places gamblings are also,
No, the main thing is that the drug, they
Yes,
take
Lord.
advantage of.
yes,
There has been a report.
yes.
These people take advantage of the weekly market they used to wait for. That probably, and an entire state, not only, and yours is suspension only. Others already cancelled.
They have cancelled. The
Ah.
Itanagar's other he have tendered
So
one.
since you have submitted
Cancellation.
representation before the
This
deputy
is a
commissioner,
suspension only, suspension.
taking into account the present situation, the deputy commissioner will decide your representation. Okay, well,
Meanwhile, Your Honor, that the operation
direct,
of the,
we will dispose of with the direction to the deputy commissioner to dispose of this representation within 30 days. Okay.
Your Honor, meanwhile, that the operation of this impugn order may be stay. Because Your Honor,
So how that can,
every,
how that is possible, you see? It was suspended when? It was suspended
In May, Lordship,
May 25, and since
First May.
then,
1st of May.
it's not there, huh? April. 30 April or what?
30 April, just
Hmm.
very next day.
So
And there was no.
we'll dispose of that with the direction to deputy commissioner to dispose of your representation, to representation, okay?
Lordship, to that effect only. Otherwise.
Within
Lordship-
30 days,
Mm.
okay? Okay, you are Mr.
A Bodo,
Mr.
A Bodo,
K,
Bodo.
where is your name? This is item. Your name is there?
Yes.
A Bodo.
Yes, sir.
Okay, A Bodo, learning counsel for the petitioner. Okay, also heard. Mr. Baha. Learned.
MSc.
In a dominant way.
Lordship, for all the respondent.
For all the respondents. What I'll do. Okay.
Like.
Right.
May I please, Your Lordship?
Yes.
Also, filed this petitions, my lord, challenging the impugn NIT issued by the respondent authorities, by which, my lord, the basically on 2 points, my lord, 2 counts, my lord. The first is arbitrary and unreasonable, my lord, clause has been incorporated, by which, my lord, the petitioner has been debarred. And another is, my lord, the respondent authority, tendering authority, he remained absent throughout the entire, my lord, the tender process, for which, my lord, the petitioner has compelled to lodge a PIR before the concerned police station. And accordingly, notice has also been issued to the, my lord, the respondent who is the, my lord, tendering authority, executive engineer, my lord. My lord, if Lordship peruse the, my lord, the NIT, Lordship will find the unreasonable and unjustified, my lord, the clause. For a moment, my lord, may I take your Lordships to the page number 34 of my writ petition, my lord. Page number 34, impugn NIT, my lord. National competitive bidding, my lord. I am eligible and I am qualified to participate in national bidding, competitive biddings, my lord. I'm a class 1A registered contractor, my lord. By virtue of that, my lord, I am competent and eligible to participate in the such national competitive bidding, my lord. My lord, work is for upgradation of, Lordship will find at column portion, my lord.
Yes.
Name of the work, my lord. The upgradation of Vyomsa ADC headquarters to Lirmova EAC headquarters, road under so and so. Amount put to tender is 29 crore 70 lakhs, madam. And the earnest money, madam, that is another. Now, madam, Lordship will find at serial 1, madam. Serial number 1, box, madam. Madam, date of issuance of NIT is 30th June 2025, and last date of the submission of the tender is 14 July, second column, madam. 14 July 2025, madam. And the opening date and time of opening bid is 15, madam. 15 July, madam. Now, madam, by which, madam, the petitioner has been debarred is, madam, and so many others, madam, the intended tenderers, madam. May I read serial number 5, madam? Serial number 5. The bids can be deposited before the time specified by paying the cost of the bidding documents non-refundable in cash, madam. Cash of Rs 10,000, rupees 10,000, along with the EMD and other original documents to the Executive Engineer, Yamsa Division, so and so, from 30th June 2002, 5th June, madam. Madam, kindly, madam, take note of this, madam. 5th July 2025, during hours at the specified openings place for the work listed in the tender, madam. Madam, just for a moment, madam, I'll put pause for a moment, madam. Madam, date of submission of tender is 14 July 2025, whereas madam, last date of submission of the original documents along with the EMD is 5th, madam. Madam, the submission of the bid is fixed on madam 14, but madam, much ahead of the madam, the last date of submission, madam, original documents and other madam processing fees has to be submitted much prior to the madam, the original date of and the last date of submission of the bid documents, madam. So therefore, madam, how madam, the petitioner went to the office of the madam, the executive engineer, the tendering authority on third, on second, on third, on 5th, madam, on whole day in the whole madam, in this entire madam period till date, madam, the executive engineer is remain absent, madam. Now, madam, for a moment, madam, madam, visited the office of the madam, the executive engineer tendering authority along with my madam, the fees and all, madam. The fees has to be deposited, as lordship has already seen. The case amount has to be deposited, madam. Then, madam, the other procedures will be madam, followed by allowing them to madam, proceed further. Then, madam, the online submission will be allowed, madam, permissible, madam. Madam, I came with the all the original documents before the tendering authority. Madam, kindly peruse page number 56, Annexure 5. Just for a moment, madam. EMD, madam. I visited the office of the madam, the executive engineer on 5th, oh sorry, madam, 3rd. On 3rd, madam, on 3rd July 2020, madam, this is the EMD, madam. Cash amount of the madam, the EMD along with this other tender documents. Madam, documents and entire things has been already submitted before the executive engineer. That has already been received, madam. But the cash amount, madam, processing fees has not been accepted, madam. So therefore, madam, this is amounting to denial of madam, the petitioners from participating in.
Page 26 is?
Page 25, madam.
25 is affidavit.
Page 56, I'm sorry, madam. Page 56 is the EMD, madam, original EMD, madam. As lordship has already seen, in clause 5, there is a mention about the madam, the EMD and other original document has to be submitted on or before the 5th of July 2025, madam, whereas the last date of submission of the tender bid online is 14 July 2025, madam. So therefore, I came with this EMD and other original documents before the executive engineer, which has also been submitted along with the relevant other requisite documents, madam. It is also pending before the it is a record is available with the executive engineer, madam.
Now, what is this 26?
Madam,
Page, what is this 26?
26 is the the EMD amount, madam. EMD amount.
Okay, this is
Page
government
56, madam. I'm sorry, page 56, 56.
What?
Annexure 5, madam.
Annexure?
Annexure 5, page number 56, madam. 56.
Okay. I thought 26. 56.
56, 56.
Okay, yes.
Yes, madam. This is the address to the executive engineer, Yamsa Division, madam. Madam, this that is second, madam. 2nd July 2025, madam. Last portion, madam, maturity date, Belu, madam, Belu, last column, madam. It starts from the Belu date.
Yes.
Yes, madam. 02 2nd July 2025. And amount is, madam, as per the interest. 39 lakhs 70,000 malad. This is the amount malad. As per the malad, the amount put to tender, the calculated amount is 39 lakhs 70,000 malad, EMD amount. Now, malad, this has been acknowledged, duly acknowledged by the executive malad junior engineer who has been assigned the work to receive the copy of the malad, the tender document by the respondent authorities.
Yes.
Lordship will find at Annexure 8 series malad, page number 868 malad, Annexure 8. This document has been duly received malad, the application, my processing fees, everything has been deposited with the malad, the executive engineer, but that has not been processed malad. For which malad I am barred and debarred from malad participating in the online tender process malad. Page number 68, Annexure 8, type copy is next page malad 69 malad. Married malad. Language of the malad, the executive junior engineer who has been assigned to work to receive the copy and the other documents malad. The understanding has been assigned the work of receiving the processing fee malad and the earnest money deposit from the tender biddings for the work upgradation of Yamsa headquarter ADC 2, Lirmova EAC headquarter road under so and so duly after application and tender documents have been verified by the executive engineer, PWD division, but due to, this is the important one, but due to absence of the concerned authority, the person assigned for receiving and forwarding applications could not provide us with the said application, and that is why we unable to receive the processing fee. They are denying, admitting the processing fee and other EMD has not been received from the petitioner. Processing fee and EMD from the petitioner company. And next page, again another junior engineer. This is
Why they have written this? Who? Before whom? So giving it, this certificate was given to you.
Yes, this has been they are saying that we have received the copy of the applications from the petitioner on 5th July 2025. However, the absence of the executive engineer who is the tendering authority, initiation has to be done, process has to be initiated by the executive engineer so that the process and other things will be accepted, and by that way it will be generated for uploadings in the website. And another junior engineer who has been also assigned the same work, page number 70.
This
type copy is
this is two junior engineers.
Yes, two junior engineers. Junior engineer, he is stating that he has been assigned the work to receive the copy, from the intended tenderers, This is the only testify, the testimony of the junior engineer who has been assigned the works to receive the copy of the EMD and other processing fees. Processing fee has to be deposited in cash, not by way of other things. Unless received by the tendering authority, other things cannot be proceeded further.
So the processing fee was not received by junior engineer.
Yes, madam. No, received.
On the instruction of the executive engineer.
No, it has been received, but that has not been processed by the executive engineer.
The cash amount was also received by the junior engineer.
Yes, madam.
But it could not
the application, madam.
Because of the instruction by the executive engineer.
Yes, madam.
So this certificate he has given to you.
Yes, madam. Exactly, madam. Next page, madam, page number 70, and the type copy 71, madam. Same declaration by the junior engineer. May I read, madam? I understand being an employee of the PWD division, PWD Yamsa division was a duty of the receiving applications from the tender bidders for the work so and so from the with effect from 30th June 2025 to 5th July 2025. On dated 3rd July 2025, I have received the application, madam. This is very important, madam. Received the applications from the Badri Rai and Company, petitioner, Station Road, so and so. This is the address, madam. And on dated 4th July 2025, I have received the applications from the one that is another intended tenderer, so and so. I have forwarded the said documents to the executive engineer, PWD Yamsa division, for verifying the bidders' documents for further pursuit. But he was unable unavailable at division office during the office hours from 3rd July 2025 to 5th July 2025 due to reason not known to me, madam. This is the executive, junior engineer, Mutu Yamsa, JE Yamsa section, and Jumken Karva, JE Yamsa section, madam. And malad the Tamken Gamlin is also malad, that's one of the signatories, madam. Now, malad, Tamken Gamlin is also the junior engineer, madam, of the same division, madam.
This is the same person, junior engineer, have declared two declaration on 5th, 7th. Same person, Mutu
Yeah.
Yamcha. Jumken Karwa,
Yes, madam.
isn't it?
Yes, madam.
Why two certificate?
This certificate, by this certificate, malad, they are giving the testimonies, then declaring and stating the
Testimony before whom?
before us, malad.
Okay.
In our favor, malad. Copy has been received. Application, if language is very clear, malad, application has been received by them, malad. But been proceeded further due to malad the unavailability of the executive engineer, malad.
Okay.
That therefore, malad, that has not been proceeded further, meaning thereby, malad, tender documents, other things has been denied to the petitioner, madam.
Okay.
He has been denied
Along with the others,
malad.
along with one other applicant, one MS Rinya Youngpo.
Yes, madam.
Construction also.
But he is not before your lordship, madam.
Okay. So,
We are the first, malad, the Badri Rai company, malad, the petitioner, madam.
okay.
Yes, madam. So, malad, our alternative option, we made a representation before the concerned authorities for extension of the time to file, malad, the submit the original documents and the processing fee, malad, before the executive, malad, the superintending engineer, malad. Accordingly, malad, superintendent engineer, basing on our, malad, the representation by which, malad, the last date of submission of the original documents has been extended from 5th July to, malad, 10th July, malad. Lordship will find at page number, malad, 73, type copy, malad. Annexure 9, madam. Page number 73, madam. Even executive engineer, madam, this executive engineer has not at all responded. But however, madam, his superior, madam, superintending engineer, madam, issued the corrigendum. Lordship perused the, madam, the wording, madam, it is very much clear, madam. May I read, madam?
Yes.
Corrigendum of notice inviting tender, madam. NIT, madam, reference is so and so, same, madam, NIT, package, same package, the upgradation so and so, madam. Now, madam, the following corrigendum is being issued to the above NIT documents and to be read as follows, madam. Serial number 1, pre-bid start date and time, 10 July 2025, madam. This is the corrigendum, madam. And second, madam, serial number 2, the pre-bid end date of time, madam, 10 July 2025, 1200 hours, madam.
Okay.
And physical.
So 2 hours given.
Yes, madam. Another 5 days has been extended, madam, by the superior officer, madam, the superintending engineer, basing on the, madam, the impugn, madam, the NIT, madam, issued by the respondent number 4, the executive engineer, madam. Serial number 3, madam. Physical submission of EMD.
How many days you given?
Madam, 5 days, madam.
Where? 10 days.
Earlier it was 5 July 2025.
Okay, from there.
Yes. That
From
again
the-
extended to another 5 days, meaning thereby, madam, 10 July 2025 is the last date of submission of the. Yes, madam. Madam, third column, madam. It is important, madam. Third column, madam. I'm reading page number 73, same page, madam. Serial number 3, madam. The physical submission of EMD, tender fees and the necessary documents, madam. This has been extended to tender fee, original copy of the EMD and the copy of the contractor registration should be submitted to Executive Engineer, Yamsa Division at Yamsa from 30th June 2025 to 10th July 2025
Okay.
during office hour.
Okay.
Madam, the irony is, even this corrigendum has not been taken into considerations by the executive engineer. There was no
Earlier NIT was issued by whom?
executive engineer, my lord.
Okay, this was issued by corrigendum
By the superintending engineer, my
or
lord.
the addendum.
Superior to the, my lord, executive engineer.
Who has the right and authority to issue the NIT?
My lord, this corrigendum, admittedly, my lord, executive engineer. My lord.
Executive engineer.
Yes, ma'am.
So can he issue?
My lord, he can issue given directions to the subordinate officer by virtue of the, my lord, the senior officer to the my lord, the executive engineer who issued the original tender and the bid documents. My lord, this has to be taken into consideration by issuance of the by issuing corrigendums in the original NIT, my lord.
By superintendent engineer can
No.
also issue.
No, my lord. This corrigendum has to be after all issued by the, my lord, executive engineer, my lord. There is a column, my lord.
Hmm?
Issuance of, my lord, corrigendum is given in the, my lord, page number, my lord. Just for a moment, may I take your lordships to again page number 34, impugn NIT, my lord. Corrigendum, my lord, basing on this corrigendum, it has to be, my lord, uploaded in the website, my lord. That has not been done.
Mhm.
Page number 34 again, my lord.
Yes.
Column serial number 6, lordship will get.
Serial number?
Page number 34, serial number
Yes.
6, my lord.
Six.
The bidder should keep checking the website for any addenda oblique corrigendum to the notice oblique bidding documents till the last date of the online submissions of the bids, and bidders should incorporate the same in their bidding documents. By this clause, corrigendum has to be issued in the same website, but that has not been done admittedly, by the executive engineer. The executive engineer not at all the remain present after issuance of the the NIT, impugn NIT, all the way the we are from the different location, travel to the interior part of the district where the NIT was floated. But then the officer, the in-charge, the tendering authority, who is the executive engineer, he remained absent all the days, entire the tender process. So without having any other alternative option, we compel to even lodge an FIR before the police station. The lordship will find the basing on which we file an FIR before the concern of police station. Page number 74. FIR before the officer in charge Yamsa, the police station Yamsa. Page number 74, annexure 10. This is the FIR, particularly lodged against the executive engineer who fled full game with the intended tenderers and other Susan intended bidders. So basing this is the FIR, the complaint seeking registration of FIR regarding deliberate construction obstruction, married the subject obstruction, criminal negligence, and malified conduct by the by Sri Doge New York, the executive engineer, the Yamcha division PWD. He is the executive engineer who is responsible for entire this tender process. And this complaint has been taken into cognizance by the officers in charge. Accordingly, someone and the notice was issued to him. Lordship will find at page number 76, annexure 11, in sense tender process, how the civil such a civil nature of case tender process that can be before the extreme situations this comes. In extreme situations, the case has to be registered alternatively, ultimately. Notice issued to the lordship may see at page number
So this complaint was before the OC, not before the authority.
not before the authority. Of course, the FIR has to be lodged ultimately to the officer in charge. Deliberate, remain absent in the office, leads to this particular FIR. Having no option, the FIR, every representation has been also submitted, every DVR has been also done. But then the executive engineer, he himself remained absent from the office, for which the petitioner has been technically debarred from participating in the tender process. Notice issued by the officer in charge, matlab page number 76, matlab to Sri so and so, executive engineer PWG, matlab. This is to inform you that a complaint has been received on dated on 6/7/2025 at PS from Sri Kali Amsa and Sri Kartavi Amsa to the effect that as per the tender process, the published by so and so, matlab so and so for the work up so and so, matlab. They personally visited the executive engineer office on 3rd July 2025 and 4th July 2025, remaining present from 9 a.m. to 4 p.m. to submit their documents. During this period, their tender and relevant documents were received by the subordinate officials of the executive engineer office, but due to continuous absence of the executive from the office, they could not proceeded further with the tender process, which deliberate misconduct and abuse of the official positions and the criminal breach of trust by public servant, knowingly disobeying the law with the intended to cause injury, framing incorrect record, or acting to cause loss and mischief, causing damage to their legal rights and business interests. The investigation is being carried out by the undersigned. It revealed that there are reasonable grounds, reasonable grounds to question you to ascertain facts and circumstances. Hence, you are hereby informed to appear before the undersigned on 12 July 2025 at 10:00 hours, positively in connection with the above cited complaint. Failing to attend the so and so attracts the so and so. Accordingly, on 12 July 2025, he appeared before the officer when he has given the statement confirming that no, he was busy in other work, so he was not in the office. So by this way, he has been, the petitioner has been debarred technically from participating in the tender process. And thereafter, what happened? How seriousness is in this case is clearly reflected from this police proceedings and the initiative by the officer in charge, as well as the respondent number 6, who is the assistant engineer, page number 77, annex 12, married. This is again addressed to the officers in charge. The seriousness of the case is also reflected from this letter also. The request for safe custody of the tender document. I would like to bring to your kind notice that all the required documents, tender document papers related to the ongoing tender process, they conducted by the PWD department and are currently kept inside the office room of the PWD Yamcha division. The said room is presently locked jointly by the department and the bidders. However, the office room is not fully secured, and I am concerned about this, the confidentiality of these important documents. In view of this, I kindly request you to collect all the tenders documents in the presence of my junior engineer, Sri Damken Gamlin, and keep them in your safe custody until further instructions of the tender proceedings. This request is being made to ensure the protections and the transparency of the tender process. After the tender, the expiry of the last date of submissions on 5th July, this letter has been issued by the assistant engineer, respondent number 6, who has been personally implemented as one of the respondent, is respondent number 6.
Why he has been implemented?
He is the whole the playing games with other tenderers and the other official
ASW.
ASW. He forged the document, he forged the signatures of the executive engineer. He impersonating the official capacity of the respondent number 4, executive engineer. Whereas he is the ASW. Lordship will find at same the page number, just for a moment, page number 81, annex 15. He himself constituted the board, he himself initiated the everything. Whereas the superior officer is there in the, but he has not bothered to even obtain this office order by which the board has been constituted by the मतलब then मतलब executive assistant engineer मतलब ASW मतलब respondent number 6 मतलब signature altogether 11 members board has been constituted by the respondent number 6 मतलब kindly see the signature the executive engineer PW division.
So this is not the executive engineer signature.
Yes madam, exactly
It's a
madam.
signature of assistant engineer.
Assistant engineer. Lordship has already seen the signature of the executive, the assistant engineer at page number 77, madam. Just for a moment, madam. Page number 77, madam. 12, madam.
Okay, let us see. What is your prayer?
Now, madam, my failure is, madam, since this entire tender process has been done in collisions with the entire provisions, madam, an arbitrary and the unreasonable clause has been incorporated by which the petitioner has been devoured. And madam, we have not been given an opportunity to participate in the tender process. Fair and transparency has not been maintained. So therefore, madam, at this stage, madam, the impugn, madam, we are basically praying for the setting aside of the impugn tender, madam, impugn NIT, madam. And in the meantime, my lord, we are afraid that interim protections that the entire tender process has been maybe my lord stay till the the finalization of this writ petitions, my lord.
Ultimately, how many of them have participated?
My lord, two only, my lord. So far, as per the information, my lord, two bidders has been participating in the entire tender process, my lord. That is much prior to the my lord the
Already awarded?
no, my lord, not yet, my lord. My lord, of course, technical bid has been done on 15. It has been opened, my lord. Financial bid.
Both qualified in the technical bid.
Yes, madam. Both qualified.
And two of you could not participate.
Yes, madam. We have not been even issued, madam, the tender process, madam. So therefore, madam, we have been devoured. Technically, we have been ousted from the tender process, madam.
Yes, sir.
Well, it's going to be one, my lord.
Yes, of course. What to do?
Can I address at 2
After
p.m.?
two?
Up to, my lord.
You have some, okay. You'll take some time.
Yes, it will take some time.
Okay. Okay. Anything?
Item number 9. This matter may kindly be taken up tomorrow since I have to leave for some medical urgency. I have to attend someone.
Like 9 tomorrow?
Tomorrow, madam. Motion column.
Okay. Okay. As prayed for by Mr. Siri, Land Council for the petition. List this matter again tomorrow. Okay.
Motion.
For motion.
Deeply blessed.
Your Lordship, I beg to mention item number 17.
Item?
17.
Mention for what?
For adjournment. The opposite party has already filed the affidavit in opposition, so this matter may be listed after 2 weeks for admission hearing, Your Lordship.
For admission?
Yes, Your Lordship.
You are
I'm for the
petitioner?
petitioner, yes.
For a petitioner?
Yes, Your Lordship.
Okay.
I have obtained consent from the opposite party as well.
Miss?
M. Yaram.
N?
M. Yaram.
Yaram. Where is it? Okay. Miss N. Yaram.
M.
Land Council for the petitioner who submits that the respondent has filed affidavit in opposition and opposition evidence in opposition of staff. Mr. With the filing of affidavit, the pleadings are completed. Okay. Miss M. Yaram. No?
Your Honor, M. Yaram. M.
Yaram, Land Council for the petitioner. She submits that with the filing of the affidavit in opposition by the respondent, the are completed and the matter is ready for hearing. Therefore, this petition may be, so this matter may be listed for admission. So they file affidavit, huh? Therefore, the matter may be listed for admission, huh? After
2 weeks, your
2 weeks,
lordship.
the prayer is allowed. List the matter after 2 weeks, okay.
Deeply obliged.
Item 8 continue, okay. The government was to submit.
matter may be pass over for
Possible
for time being, madam.
Okay. Yes.
What's your problem? For hearing of this matter next week, I think the petitioner wants to take up for hearing today, sir.
Okay, so ready for hearing.
No, I'm not ready also.
You have filed affidavit,
Affidavit already filed also.
already filed. What remains then?
My counterpart said he'll do the hearing today. So-
Hearing,
Yeah, for me, I'm ready, but if the government is not ready, I have no objection.
if the matter is ready, we can fix it for hearing then instead, okay? Mr. C. Morilana, counsel for the petitioner is present.
Pleadings are complete.
Pleading complete.
Okay, Miss, okay, Miss Riba, Lanet. Additional senior government advocate is also present on behalf of the state respondent. So the pleadings, it is submitted, the pleadings are completed and the matter is ready for hearing. So in view of the above, this matter for hearing after 2 weeks. Okay.
Applied to me.
May please, Your Worship.
Yes.
My lord, Mr. Tiwari was supposed to file objection regarding the interlocutory application. madam.
Interlocutory application is for what?
And this is for the verification of the land matter. Verification of the land matter.
No, IA is for what? This.
I already, I think, with this order, matter, this is already disposed of. madam.
Is it? Yeah. IA 133. This is 133. Where we disposed of?
And with this order, matter, I think IA 166 is, I think, completed. madam. Because Mr. Tiwari appeared after long years.
133 disposed of.
Yeah. It seems. madam. So as of today, he not filed any objection petition. So it is already completed today. subject matter is regarding land, my lord. Out of 145, 97 square hectares, the National Hydropower Electricity Corporation has just prepared only for the 45 hectares. Whereas there is a 97 square, 97 point point 875 hectares are still in the hands of NHPC. So our prayer is that verification be done.
This matter is not be listed. We'll dispose of this, probably this application under section 27 of the General Clause Act is disposed of, it appears. Disposal in that case. So he has not yet filed. Okay. Not present also today. Any?
His juniors are not present.
Okay. Then I, 33, 133. Mr. Tisan, land counsel for the applicant is present. However, no one appears on behalf of the respondent number 5. Is represent on the domain is also party here.
Yes, my lord. If your lordship is disposing the IA,
No, it may not be because the
your
respondent-
lordship may not. Why I'm saying because my lord,
we cannot. Because
Yes,
the
ma'am.
respondent number not yet filed affidavit.
even then because the prayer made in IA and the main petition is same, my lord.
Yeah. Okay.
They want the resurvey should be done, my lord. In introductory application also, my lord, prayer is same, my lord.
Same, the
Yes.
second prayer is similar to the main.
Yes.
So that may not is, that means
So-
it will remain
So,
like that.
so it cannot be disposed of piecemeal, manner. It will be hard together. my lord.
Only one port is not.
So whether in the IA, state is filing any affidavit,
I am, my lord,
133.
the NSPC, they might file, my lord. I don't have any objection.
No, government, about the government.
Okay. Okay.
My lord, in our affidavit, we have clearly said,
Hmm.
my lord, they are claiming 143 something hectares.
Hmm.
But as per our notification, my lord, the acquisition was done only 69. And wherein, my lord,
45. Huh? Only 45.
no.
45 hectares.
That's the money.
Okay, so. Analyze patient details.
My lord, no, 69.949 hectares. That is, my lord, Anya community. Now they are saying, my lord, that the NSPC, they have, my lord, covered up, or the area, total area comes under 143. That is the claim of the petitioner, which we dispute, my lord. We say it's only 69.147. And
If you are disputing, then you may have to file affidavit.
my lord, we have already filed the affidavit in
Oh,
the
you
main
have already
petition.
filed.
Yes, ma'am.
Okay, then we'll give you one more opportunity to the respondent number 5. They took time to file affidavit within three weeks, not yet filed. One more opportunity can be given.
Actually, matter was continuously, it is coming up since 2024, 24.
It's 25 only.
This is latest application.
Okay.
Prior to that, there was
The main
three
petition
more
is 2024.
IA.
Although okay, so Mr. Kison is present. Mr. Aristov, Daniel additional agent for the state respondent number 1, 2, 4. No, 1 to 3. No?
Only respondent number 3, madam.
Only respondent number?
I'm sorry, my land also, madam. Secretary Land Management.
No, you are representing the state.
Yes.
1, 2. Then also.
Land Management also, right, madam.
Okay, and the deputy commissioner also.
Land management.
1, 2,
and 3.
3. Yes,
Okay,
madam.
3.
1 to
At
3.
present, however, Mr. However, none appears on behalf of the respondent number
5.
5. Who represents 4? 4 and 5, huh? 4 and 5.
4 and
Stop.
5 NSPC, my lord.
Okay, 4 and 5. The office note dated 21/7/2025 reflect that. Also reflect that the opposite party is yet to file affidavit. Opposite party number 5, is yet to file affidavit. In view of the above, one more opportunity. In view of the above, and in absence of the respondent number 5, the matter stand adjourned. List this matter after 3 weeks.
3 weeks, already 3 weeks already given, madam.
Hmm.
As a last chance. As a last chance.
This was the first chance was given for filing affidavit after its appearance. This is matter
After 2 weeks, madam.
3 weeks. Okay.
My lord, notice to respondent number 4. My lord, is a Ministry of Renewable Energy. My lord, now, my lord, this NSPC, although my lord, is comes under the renewable energy, but it's a autonomous, my lord, enterprises, my lord. They must having their own board of director, all these things, my lord. So,
Four probably notice has not gone.
4 will
not
be
yet gone to
represented by the perhaps DSGI, my lord.
4 also notice not yet gone.
Not yet gone. Then notice has to be issued, my lord. Mr. Tiwan, perhaps he might appear for respondent number 5.
Only 5.
Only 5.
as per this order.
Yes, my lord. The 4, my lord, Mr. Kato, I don't.
Union of Winners, Secretary
It
Power.
should be renewable energy. आपको करना चाहिए मेरा ख्याल में.
Madam, I can appear on behalf of respondent number 4 also.
Okay, you accept notice?
Yes, please.
You received the copy? No.
Yes, sir. Earlier already have copy.
I'll check out,
Ah.
I'll check out from the record, madam.
Okay.
In fact, we are not
Then-
having the copy, madam. Therefore, madam, we are under preaching.
You have extra copy?
Yes, I am looking at that.
Okay. Mr. Then, in the middle, after government advocate, after AG, Mr. Tato Lanaka, DSTI, would appear and accept notice on behalf of the respondent number 5. No one appears on behalf of the respondent number 5. He for respondent number 4, okay? No one appears on behalf of the respondent number 5. Start. Then this office note, respondent number 5 yet not his file affidavit. In view of the above, the matter is stand adjourned, list this matter after 3 weeks. Okay.
Obliging.
So union also file affidavit. Mr. Kar, union also file affidavit in the meantime.
Take instruction first.
Okay,
I have only just handed over to him now, copy.
okay.
Develop.
Item number 8. My lord, this item number 8, my lord, the other side they have submitted. It's my time to reply to that.
Yes.
Now, my lord, this petition has been filed under 226, my lord.
Yes.
Now, it's a writ petition. The person who agreed or his fundamental right or legal right, if it is violated, then only, my lord, under 226, one can approach before the writ court, my lord. Now, in this case, my lord, who is before your lordship? It is not the farm owner. It is the PA holder, my lord. Power of attorney holder, my lord. Now, in locum brother case, my lord, that has been decided. The power of attorney holder cannot be aggrieved party, my lord. He cannot come before the court under 226. He is not the aggrieved person, my lord. The aggrieved person would be, my lord, the proprietor, my lord, the owner of the farm, not, my lord, the power of attorney holder, my lord. So that proposition law was settled. That was appealed before the division bench also. The single bench order was upheld by the division bench. Now, my lord, in that count, my lord, the petitioner does not have locus standi to file this petition, my lord. Number 1. Now, number 2, my lord, as my lord, they have said, my lord, in this, my lord, NIT, there are 2 bidders, successful bidders are there, which technical bid has been opened, my lord. Now they are not before your lordship, my lord.
They are not made as a party?
No, my lord, they are necessary party.
We are only challenging the, my lord, as of now, my lord, we
No.
are challenging the impugn NIT, my lord.
Any order passed by your lordship will
Now you know that
effect.
they are
My lord,
successful bidder.
my lord, it is not known when
No, you have said.
technically, my lord, the qualified will be given or not, my lord. It is not the case, my lord, they have been given, my lord. It is just under consideration, my lord. Not that, my lord, anything has been done so far. My lord, at that after opening of the bid.
No, you submitted that. Remember, submitted that
2%.
2%.
Yes, technical
Qualified.
bid has been
My lord,
opened.
so far the information is concerned on, my lord, just before the closure of the, my lord, the tender document acceptance date 5th July 2025. My lord, we have been informed that 2 bidders have only submitted the, my lord, the processing fees. That is the only, my lord, limitation in, my lord. Now, my lord, it is not known, my lord, tender process is yet not yet over. My lord, it will be sent to the higher authorities. It will
No,
be, my
no,
lord,
no.
verified. It will be evaluation, my lord, technical
Malad,
evaluation,
that,
financial.
that is not the correct fact. Malad, if your lordship see the date when technical bid to be open,
My lord,
it's already over.
come to that address.
It's already over. Now you yourself have said in paragraph 17 that 2 bidders they have, my lord, submitted their bid documents and their technical bid has been opened, my lord. Now, when you say, my lord, if their technical bid is accepted by any authority, now, my lord, they are very much active in this NIT process. Any order passed by your lordship, behind the back, they will be effective, my lord. And they are not before your lordship, my lord. So, Because if your lordship stays the my lord the NIT, my lord, that will definitely affect them, my lord.
That will affect.
Definitely. So they are necessary party, my lord. Then number two, my lord. These are the two reasons, my lord, why this writ petition is not maintainable, my lord. Now, before coming to my lord, merit of the case, if your lordship sees, my lord. Now, another, my lord, they have says, my lord. If your lordship may come to page 32, my lord. Now, main objection is page 32 of the my lord, NIT, my lord.
Yes.
The serial number 8, they are of this condition, my lord. Rest, my lord, entire petition, they don't have any objection, my lord. Only this physical submission of honest money deposit, EMD tender, fees, and other documents, my lord. If your lordship note any NIT, my lord, EMD has to be submitted in my hard copy, my lord. Although it will be uploaded in the my lord, e-portal, but one has to give in hard copy, my lord, the original one. So nothing new is there in the my lord, clause 8, my lord. Now another problem, my lord, he has said, my lord, only my lord, 5 days time was given. If your lordship see the date, my lord, 36/2025 to 5/10/2025, my lord. So 5 days. Then your lordship also must have noted the my lord, corrigendum issued, my lord. Now before that, if your lordship sees, my lord, the allegation has been made against the executive engineer that deliberately, my lord, now this officer is absent from the division, my lord. That is the allegation, my lord. Because of that only, my lord, his tender document could not be evaluated by the executive engineer. Your lordship may kindly come to the representation submitted by the petitioner, my lord. Representation P60, my lord, page 16. Well, it can. Your lordship may start from, my lord, page 57, my lord. Has your lordship got it, my lord, page?
Yes.
Top, my lord, your lordship may kindly note the dates are very important. 4/7/2025. Has your lordship got it? Top, my lord. It had been addressed to, my lord, Commissioner PWD, Government of Arunachal Itanagar. Very well. The same representation has been submitted to the Chief Engineer, then SCA. Now, I have gone through it, my enter this representation. There is no whisper against the executive engineer that this fellow is very irregular, absent in the division, my lord, and is not receiving, any authority is not receiving tender paper. What exactly they are urging before the authority is to extend the date of, my lord, submission of the EMD, my lord. Your lordship kindly see, my lord. If you lordship see the paragraph 6, my lord, as per the published tender schedule, the online submission period was clearly fixed from 36/2025 to 14/7/2025 up to 16 November, with the opening of the technical bid schedule from 15/7.
Reading where?
My lord, I'm reading, my lord, page 57, my lord.
Okay.
The representation submitted by the, my lord, petitioner, my lord. Petitioner, my lord.
Okay.
Page 57, my lord.
Page 57.
57, yes, ma'am.
Okay.
Second paragraph.
Yes.
As per published
Yes,
tender. Now, you lordship kindly skip to that manner. However, you lordship may kindly note. After 5/7/2025, next line starts, my lord. However, an additional clause was inserted requiring all bidders to submit the original document, EMD, processing fee strictly within 36/2025 to 5/7/2025. My lord, this is the objection, my lord, main objection raised by the petitioner, my lord. The time limit you have given is very less, my lord. Only 5 days. If your lordship see, my lord, entire, my lord, this representation, your lordship will not find a single line alleging any malafide or absentee of the executive engineer, my lord. Now, based on this, my lord, your lordship may kindly see, my lord, corrigendum was issued, my lord. Now, corrigendum, your lordship will find page P73, my lord. These are the representation series, my lord. They have submitted up to executive engineer, page 73, my lord, 73. Has your lordship got it now?
Yes, yes.
Yes.
Addendum. actually.
Yes, addendum, my lord. It is because of the representation submitted by the petitioner asking for extension of time, my lord, for submission of the document, my lord. Now, your lordship see, my lord, extreme right, serial number 3, physical submission of EMD tender fees and necessary document. The tender fee original copy of EMD and copy of the contractor registration should be submitted to Executive Engineer Yamcha Division, Yamcha from 36/2025 to 10/7/2025. Earlier it was 5/7, my lord. So it has been extended to another 5 days. It is all because of Malo representation submitted by the petitioner, my lord. Now, the physical submission of my EMD has been extended, my lord, up to 10/7, my lord. Now, all this complaint, these submissions, certificate issued by the engineers, my lord, if your lordship sees the date, my lord. My lord, start from page representation, engineer. Page 69, your lordship may kindly come, my lord. 68 is the original, 69 is the type copy, my lord.
Yes.
Now, I don't know, my lord, who authorized these engineers to give a certificate, my lord. Anyway, what is important is the date. Your lordship may kindly mark the date, my lord.
5/7.
Yes, down below, my lord, date is 5/7/2025. Right, my lord? Down below, my lord.
Yes.
5/7/2025. So meaning thereby, let us assume for a moment, the executive engineer were absent from 30 to 5/7/2025. Then what happened after 5/7? Because the submission of the tender document extended to 10, my lord. Why he could not submit after 5, my lord, when it was extended, my lord? It was extended to 7/10. And there is no any explanation to that, my lord. Only they could procure this type of copy, my lord, from the engineer. They similarly, if you see, my lord, the page 71 also. Same that, my lord, 71. And here, my lord, even the date has been given, my lord. I have forwarded said document to executive engineer PWD Yamcha for verifying the bidder's document for further peruse. But he was unable at the division office during office hour from 3/7/2025 to 5/7/2025. Then what happened after that, my lord? Why, if this engineers may receive, could not, my lord, adduce before the executive engineer after 5/7, my lord, when the date was extended to 10/7, my lord? So I doubt, my lord, all this document could be manufactured one, my lord. It cannot be relied, my lord. Similarly, if you see the, my lord, the affair lodged by the petitioner, my lord, the same, my lord, 6/7/2025, page 74. Did your lordship got it?
Yes.
The most important date is to be marked is my second paragraph. Your lordship may kindly come. We personally visited the office of the executive engineer from 3/7/2025 to 4/7/2025. So he himself certifies that after 4, he never visited executive engineer, my lord. Whereas tender was extended up to 10, my lord. Now he cannot deny, my lord, that that after 4 also, my lord, he has visited, that he attempt to submit his document till 10/7, my lord. He himself certifies, my lord, that he visited 3/7 to 4/7 only. Only 2 days, my lord. Now, on what basis the petition is saying that my officer is very irregular, my lord? He is never remain in the, my lord, division, my lord. And he never, my lord, ready to accept the tender document submitted by the petition. On what basis, my lord? Mere only purported some NOC certificate given by the, my lord, junior engineers, my lord, which also says, my lord, up to 5. Now, my question before you, lordship, if the junior engineer received the tender document submitted by the petitioner, why that was not produced before the executive engineer from 5 to 10? That extended period, Mala. So what we can inference can be done. These are the presumed to be manufactured document, Mala, or they might have some personal bias, Mala. I don't know exactly, Mala. Now, the allegation which they have raised, level against the executive engineer is, Mala, totally wrong, my lord. There is no iota of truth, my lord. They themselves certified that they have visited 3rd to 4th only. 2 days they visited the office, my lord, of executive engineer, my lord. Whereas, my lord, because of their, my lord, request, we have extended to 10/7/2025, the submission of EMD, my lord. Now, the paragraph 8, you lordship to see, my lord. Well, doing that, my lord, asking them to, my lord, give the hard copy of the AMD, is there any discriminatory, my lord? Will that violate any right of the petitioner, my lord? And these are, my lord, the common norms you lordship by any NIT, my lord, especially in NIT, my lord. You lordship will find, my lord, the hard copies have to be produced before the tendering authority, my lord, to demonstrate that, yes, the document which you have uploaded in the e-portal is the correct document, my lord. And your lordship knows, my lord, the importance of the, my lord, EMD. My lord, that is the basic heart of, my lord, MD tender process, my lord. If you withdraw the EMD, you are no more longer in the tender process. So EMD is very important, my lord. Now, that's why, my lord, on this 2 point, my lord, the locus standi, my lord, the petition has to be dismissed, my lord. That has been settled law. The power of attorney is not the aggrieved party. He cannot approach the court under 226, number 1. Number 2, non-joiner with the necessary party, my lord. Only 2 persons have their technical document has been only evaluated, my lord. Now, whether financial bid has been evaluated or not, my lord, that confirmation I have to take, my lord. Now, if my friend can satisfy that this power of attorney holder can approach this court under 226, then you lordship may, then we can look into the merit of the case, my lord. But these 2 points, my lord, why necessary party has not been, my lord, implemented, then the authority of the power of attorney holder to approach the court under 226 as an aggrieved person, my lord. These 2 points he has to satisfy, part. The preliminary objection which I raised.
I'm very surprised to hear that also, Malad.
No, it's the settled law. No need to surprise.
No,
Locum brothers, that has been settled.
Locum brothers was, Malad, in that case, the attorney holder directly approached as a writ petitioner, Malad. But in my case, Lordship perused the Malad applications, page number 5 of my writ petitions. Malad, it is the company, Malad, authorized to swear affidavit by authorized person.
No.
In the affidavit, it has been specifically mentioned, I am authorized to sign, Malad. That is the only, Malad, the limited duty of the attorney holder, Malad.
Okay.
But the, Malad, before your lordship, is the company only, Malad.
Just a minute. If you say company, the another question I will raise. Where is the regulation adopted by the BOD, Board of Directors, to file the writ petition? Show us. If you talk about the company law says, director cannot, whimsically or independently take a decision. There are board of directors are there. Regulation has to be adopted to file a writ petition. Where is the regulation if you talk about the company? I'm not on that matter. If Lordship may kindly come to page 7, my lord. Page 7. Why I have raised this question, my lord? Page 7, the introduction part, my lord. 1, paragraph 1, Mala. The petition is a registered class 1A contractor under Assam Public Works.
Company is the general word I used, Mal.
None, all right.
But it is registered per Mal.
Doesn't matter. Contractor, registered number so and so, duly represented by managing partner and PA holder Sri Arun Kumar Rai. Two things, Mala. Managing partner and power of attorney holder. And through its duly author representative, my lord, how can the PA holder can delegate to another PA holder, my lord? He is a partner plus PA, my lord, power of attorney holder. The Arun Kumar Rai. And through its duly authorized representative Kale Yamcha.
Authorized to sign, my lord.
No, PA holder you
My lord,
can't
my-
authorize. I'm sorry, power of authority does not have authority to establish more power to third party, my lord.
My lord, may I take a lordship
I'm sorry, my
to
lord.
clarify, my lord? My senior is in another respect, my lord.
No.
My lord,
Kindly clarify this point.
my lord, I'll clarify, my lord.
Chalo.
First of all, my lord, page number 5. Before your lordship is the per, my lord. Page number 5, my lord. MS Badri Rai and Company, my lord. Is the my lord per. And deal represented by its managing partner and PA holder. My lord, he is managing partner as well as PA holder of the work, my lord, this particular package of work, my lord. That is the first limb. And the second limb, my lord, for swearing of authority, my lord, the company can give any person authorizing him to sign affidavit, my lord. That's it, my lord.
Who authorized this? Kali Yamcha?
Kali Amsa, my lord, one of the managing partners, my lord. And managing partner, my lord, they have authorized the one. To clarify that aspect, my lord, may I take your lordships to Annexure 1, page number 26 again, my lord. Annexure 1, page number 26. This is the my lord, certificate given, my lord, the company's registration, and my lord, the registration number and name of the contractor, Farm Company, my lord. Badri Rai and Company, Arun Kumar Rai, my lord. Arun Kumar Rai, my lord. My lord, he is every right to, my lord, authorize the persons who will sign affidavit on their behalf, my lord. So therefore, there is no issue, my lord, to my understanding. And my lord, the page number again, my lord, page number 27, my lord. Page 26 is the, my lord, the lordship will find at column number 2, my lord. Name of the company, contractor, my lord, so and so. Badri Rai and Company, Arun Kumar Rai, my lord. He is the, my lord, the authorized person, my lord. And my lord, page number 27, again, my lord. Name of the, my lord, the partner is Arun Kumar Rai, Ajay Kumar Rai, and Anuj Kansal, my lord. All are partnership, my lord. So by virtue of this, my lord, documents, page number 28 has been issued, authorizing one Sri Kali Yamcha to, my lord, sign affidavit, my lord. Page number 28, my lord. My lord, he is not coming before this honorable court directly, my lord. He has only been authorized to sign affidavit, my lord. Therefore, in affidavit portion, I'll take your lordships to affidavit portion also. Hereby authorize Sri Kali Yamcha to file a petitions on their behalf and the executive engineer against the executive engineer regarding the fraudulent activities related to the tender process. The name of the so and so. We grant Sri Kali Yamcha full authority to represent us in any legal matters concerning the subjective case only, including, but limited to submitting documents, attending hearing, and taking all necessary actions to seek justice. This authorization is given voluntarily with the full understandings of the natures and the legal implications. Thank you for your attention. Sincerely, Sri Arun Kumar Rai, Managing Director and the Power of Attorney. managing partner, as well as, my lord, the power of attorney holder for this package of work, my lord. So therefore, he is of every, my lord, the right to, my lord, authorize any persons to sign affidavit, my lord. Now, my lord, annexure, page number, my lord, again, affidavit portion, my lord, if lordship see the affidavit portion, my lord, to page number 25, my lord. Page number 25, my lord. My lord, Kali affidavit so and so, A so and so, so and so. I have been duly authorized by the Badri Rai and Company, a petitioners of this instant writ petitioners, to swear this affidavit on their behalf in connections with the present case, my lord. This is the only, my lord, limited duty and the power, my lord, that confers to this, my lord, the Kali to sign affidavit only, my lord. Affidavit has to be my lord, petition has to be supported by the affidavit, and affidavit has to be signed by the, my lord, directly company cannot come and sign the affidavit, my lord. Affidavit has to be sworn by the one authorized person, my lord. And company, the, my lord, whosoever may be, no, even company, even the, my lord, the legal, my lord, having legal entity, they are authorized to file, my lord, empower and authorized to, my lord, authorize any persons to swear affidavit, my lord. There is no, my lord, restriction and a bar, my lord. Now, that is the one aspect, my lord.
Okay.
My lord, second aspect, my lord, regarding the, my lord, non-implement of the, my lord, the response. My lord, as of now, we don't know who is going to be, my lord, the award the work, my lord. Only tender process is going on, my lord. At the very stage, we are, my lord, approach your lordship for lordship anticipation, my lord. It is not yet finalized, my lord. So it is not, my lord, only mere participations will be not, my lord, made as a party, my lord. My lord, in the technical evaluation, in the financial evaluations, their, my lord, bid may be rejected, their bid may be accepted, my lord. As of now, we don't know, my lord. Unless it is finalized, my lord, then, my lord, admittedly, when we know about the, my lord, the finalization of the tender by awarding the, my lord, accepting the, my lord, the tender voted by the, my lord, the interested bidder or the parties, my lord, definitely will include them as one of the respondent, my lord. My lord, this is the initial stage. As of now, my lord, we don't know whom the work will be awarded, my lord. So therefore, my lord, the implement of the, my lord, other party will be necessary, unnecessary, my lord. Even we don't know, my lord, who has participated. And as of now, my lord, the record is not revealed, my lord. Now, my lord, the irony is, my lord, my record, documents, and everything is in the safe custody of the, my lord, the superintending engineer. My lord.
When this was filed?
My lord, it was filed on 21st, my lord.
21st.
Yesterday, my lord. My lord, during the such period, lordship, aware, my lord, this all period was the holiday, my lord. So therefore, we cannot, we were unable to file, my lord, this petition. Moreover, there was a holiday, my lord. And, my lord, regarding, my lord, 30 to 5th July 2025, my lord, my senior has pointed out, from 5th July to 10th July, where we have been, my lord. My lord, that is completely, my lord, not correct. It's because it has not been extended, my lord, as I have pointed out. My lord, corrigendum has not been taken into, my lord, on the very beginning, my lord, I have pointed out, though there is a corrigendum issued by the, my lord, superintending engineer, that has not been taken into consideration.
After issuance of this corrigendum, or the addendum, actually it should be addendum, not corrigendum. There was no mistake.
Yes.
Corrigendum is when there is a mistake, okay. But it should have been addendum.
Addendum, yeah.
After issuance of addendum, have you tried to submit your?
No, my lord, that has not been extended. That has not been, though, in, my lord, technically, my lord, as per the provision, therefore, my lord, clause 6 has been, my lord, read out.
It has to be issued by the executive engineer.
No, my lord. Corrigendum has been issued by the superintending engineer, who is the higher authority of the executive engineer. But as per the tender process, my lord, tender, the addendum or any corrigendum or any other things has to be done by the executive engineer only, my lord.
Executive engineer did not do. That is why you could not submit.
Yes, my lord.
Okay.
Still, there is a prevention from submitting anything, my lord, till 14, my lord. Only 14, my lord, my lord, if we had issued advertisement, my lord.
So, We can issue notice at the moment.
Issue notice already.
Interim period, just the
No.
constable maybe.
My lord, I-
Only to the extent not to finalize.
Yes, my lord.
No, your lordship may not pass that. Your lordship may kindly see
my lord.
page 28.
Hmm.
The learned council has said, my lord.
Hmm.
Now, this
No, in the-
Kali, my lord,
Hmm.
Kali Yomcha has been only authorized to sign the affidavit.
Hmm.
Right, you have said so. Right. Your lordship may kindly come to page 28.
That will become later on, my
No,
lord.
no,
That
no.
issue
No, no.
is different,
No,
my
no,
lord.
no.
Completely, my
No,
lord.
no.
Another aspect.
I'm sorry,
28, yes.
28.
Hmm.
We MS Badri Rai and company. My lordship may kindly mark company.
Hmm.
The company means it must have registered under the Company Act also, my lord.
Mhm.
And when we say company, there is board of directors are there. Right, my lord? Now, here the authorized Sri Kale Yomcha to file a petition, not to file a affidavit only, my lord. To file a petition. Now, who filed this? Kale Yomcha on behalf of my lord Badri Rai.
No, my lord.
That's why I've said, my lord, if the Kale Yomcha is the power of attorney holder, my lord, he has no locus. If he only to authorize also, he does not have the locus, my lord. It is only the proprietor of the farm or company or any other legal entity only can approach under 226, my lord. Which my friend has not replied to that, my lord.
My lord, paragraph 1 clearly stated.
No, no.
My lord, this is something,
Now-
my lord, that
now-
issued by the,
Another thing,
my
my
lord, that is company's documents.
Another thing, if your lordship see, my lord, technical bid opening, 15/7, my lord. Now we are in 20, today's what, 22. My lord, only pass, my lord.
Therefore, my lord,
No,
not to
that-
finalize it.
No. We don't know that after that, my lord, things must have technical or after technical, my lord, financial bid must have been opened, my lord. We don't know.
My lord, there is nothing to
But
be confused.
I'm
My lord,
only-
page number 7.
Only thing that why did you fail to submit, my lord? Why was the wrong to submit the hard copy EMD to the executive engineer, my lord? Why
My
are
lord, person who is not at all available in the office, my lord.
why no why are you
My lord.
agree with clause 8, my
No,
lord?
in your representation, you did not say anything about
Anything, no,
My
my
lord,
lord.
which one?
Your
the
representation.
submitted.
My lord,
Representation.
by that time, we are trying to submit the, my lord, the processing fees for, my lord, uploading the documents in the web portal, my lord. Till such time, my lord, we were under process, my lord. But, my lord, in the office, my lord, police note, my lord. Lordship has seen, this is the officers in charge who has taken cognizance of the entire thing, my lord. Has clearly given in the notice that you will not remain present in the office till such and such time. This is official, more official documents than the documents of the petitioner, my lord. Lordship perused, my lord, the notice issued by the Lordship has already seen the copy of the, my lord, notice issued by the, my lord, officers in charge, my lord. This is authentic documents, my lord. It is not by me, my lord. It is the documents of the officer in charge, my lord.
You're talking about
I
the
have
affair.
no idea if that the absence in the office can be filed before the IO of the case, IO of the police
My lord,
station.
how can he take this cognizance, my
No,
lord?
my lord.
He cannot
FIR
take
has
this
been
cognizance.
lodged.
Even
He has been summoned to appear, by which, my lord, it is by this, my lord, we cannot rely upon the documents of the petitioner, my lord. Okay, my lord. But documents of the, my lord, the police officer is very much important, my lord. This is the official record, my lord. This is the documents, my lord, which has been issued by the concerned police officers saying that you were not remain present on such and such date. My lord, we have been prevented. My lord, does it mean that, my lord, during the holiday, my lord, when the court was not sitting, my lord, we have been forced to move such application? No, my lord, it cannot be. When officer was not there, my lord, whom do we approach, my lord? Therefore, my lord, we compelled to lodge an FIR before the concerned police station. The officers in charge of the concerned police station, my lord, this is a sufficient documents, my lord. It is not a public, it is not a private document. It is not the documents of any individual person, my lord. This is the public documents of the record of the concerned police station, my lord.
Acha, kindly read the contents that will clarify, my lord. This is just a replica of the affair lodged by the petitioner.
My
my
lord,
lord.
this is a very,
Nothing else.
important case, my lord.
Nothing new is there, my lord. This is just a replica of
My
the
lord,
complaint
this is
lodged by the
document-
petitioner, my lord.
Otherwise, my lord, if
My
there
lord.
is no such case, my lord, why officer in charge has taken cognizance of this case, my lord? It is not required. It is first time happening in the such tender process, my lord. In other tender process, as I have already submitted, my lord, such interference of the police administration is not required, my lord. The police administration should be required only when there is a law and order problem. But in this case, my lord, deliberately, when the officer concerns remain absent from the office, not allowing us to submit the, my lord, the processing fees and other things, my lord, this is a very serious issue, my lord. So therefore, my lord, no, my lord, the lordship has already taken a view, my lord, that order may be passed, my lord, not to finalize it, my lord, ends of the justice will do, my lord, let them file affidavit, my lord, everything will become black and white, my lord.
Not at your cost, my lord. Public interest is very important, my
No,
lord.
my lord,
Public
not yet,
interest.
sir,
At your
my lord,
cost.
not yet initiated anything. Had it been the case that, my lord, the work has been awarded, had it been the case that, my lord, it is not the case where, my lord, only the tendering authority is empowered, my lord. This amount put to tender is 29 crores, my lord, 70 lakhs. Therefore, my lord, approval has to be done by the chief engineer and at the higher level, my lord. So it will be not directly awarded by the, my lord, the executive engineer. That better knows by my senior.
That we all know, my lord.
That,
we
so
know
therefore, my
tender
lord, it is
process.
not the case wherein, my lord, directly, my lord, work will be awarded to. So therefore, not to finalize it, my lord, the ends of the justice, my lord, even if, my lord, if we don't have case, admittedly, my lord, there is a provision always for the, my lord, dismissal of our petition, my lord. At this stage, what we need is, my lord, may kindly interfere. My lord, such seriousness of the case has already been seen by your lordship. So therefore, it is a pit case for interference of your lordships by staying, my lord, the entire.
Still, I will say, my lord, my brother has not answered to my question about the local standing.
We have answered, my
If
lord.
it is a if it is a company, where is the board of director decision, my lord? Because company is always headed by the board of directors.
That is there.
Now they are saying,
But,
my lord, sometimes they are saying, my
but,
lord, it's a company, sometimes they are saying, my lord, it's a farm, my lord. And how come,
My
my
lord,
lord,
page number
how
seven of merit petition, my lord.
How come, my lord, PA holder can authorize someone else, my lord?
No,
Suppose-
my lord, not PA order, my lord. Page number 7, my lord.
You
Para
say,
one, man.
you say that it was
You
farm.
said so.
Now here, it appears that you, the company, when authorized, in the authorization letter, you say that the company.
Yes.
Then if it is a company, then of course, board of
My
director.
lord, issue is not that, my lord. Issue is
So,
the
but
grave,
whatever may be, since
greater
he was
interest is,
authorized,
my lord, greater interest is such by anomalies, by arbitrary.
We'll keep this also open.
Yes,
My lord,
let me be open. my
if
lord.
you see,
Always
my
there,
lord,
my
if
lord.
you see, my lord, greater, my lord, interest, my lord, best, my lord, judgment would be like Jagdish Mandal, wherein Supreme Court had repeatedly said, until unless overwhelming public interest is involved, my lord, no interference is called.
We'll keep this open, you,
My lord,
citation.
yes, my lord. I can give tomorrow itself, my lord. And so far, my status, if your lordship wants, let this matter be taken up Friday, my lord, so that I can update, my lord, what happened after that. I believe, my lord, financial bid must have been open, my lord. Because 15/7, it was the technical bid opening day, my lord.
My lord, of
Now we are at 22, my lord.
all High
this-
Court, my lord, wherein
this-
non-selling of.
yes, my lord.
Now, if that is if the.
So your lordship may not pass any order, let this matter
Then
begin
in that
come
case, probably you may have to make them party. No adverse order can be passed against.
against the,
My lord,
respondent, private
not to
respondent.
finalize will be sufficient. In the meantime, my lord, if work is awarded to anybody, my lord, any firms, my lord, definitely they will be implemented as necessary party. There's no issue, my lord. My lord, as of now, my lord, what we are praying for is, my lord, interference of your lordships. My lord, it is a fit case wherein, my lord, your lordship can pass such order not to finalize, my lord. My lord, if finalized, definitely they have every right, my lord, under 226 my lord, Article 226, subsection, sub clause 2, my lord, for modification and altercation, my lord, there is always provisions for.
that is different issue.
My lord.
My lord, staying any, my lord, development activity, will that be a public interest? This is
That
most
true.
important.
But here you see, what we could see from the face of it that subsequently he has made a statement and the two junior engineer has also declared that he never appeared. He said that not to accept.
No, my lord, there is
Two
nothing in what the junior says, my lord.
And then
My lord, they
subsequently
could,
they have filed FIR before the police. And then the police has also gone into the office.
my lord.
So these things, prima facie, it appears that there is something in it. That is why.
That's why, my lord, your lordship may not pass any order. Let this matter be come up again on Friday, So that let me speak to the
No,
office of what happened exactly, my lord.
That can be done.
That can be done. Then, my
You
lord,
obtain instruction that
yes, my lord, that will be,
My lord,
because
my lord,
in any case, if this technical bid has already,
It's
and the
already
technical
open, my
bid two, open and two have declared, then you may have to make them as
Necessary
as a
party.
party,
My lord.
respondent party.
my lord, may kindly appreciate one thing. It is the practice of the every government department in such tender case. My lord, they will finalize in every backdated documents and they will produce before this honorable court saying that everything has done already done much before the my lord, the filing of the
Now you
That
see,
is a
we
wild
cannot-
allegation.
We cannot come into such conclusion because the authority, chief engineer, SC, whosoever may be, the authority above the executive engineer may not be in support of the executive engineer.
Yes.
So in that case, since the matter has come into the court and then the Ghana advocate, additional advocate general also will obtain instruction from the authority who will be probably,
Ultimately, my lord, approving authority would be chief engineer, my lord.
Yes.
So
So
executive
that way-
engineer,
that
he
way,
can't do himself, my lord.
that way they may also not support.
That, my-
So what we can do is you obtain instruction that in that case.
Yes,
in
my-
that case,
And
madam,
in
day
the
after
meantime,
tomorrow.
in the meantime, since you have raised the locus also,
my lord,
Yes.
so
nothing heaven will fall day after tomorrow or Friday, my lord, because it's from Yomcha. I have to take telephonic, my lord. As you have said, the person is missing. I have to press him off first.
and then you see, you have seen that there is an FIR against the executive engineer also.
My lord, that also, my lord, we can take an instruction. What happened, my lord? If there is any inquiry, my lord, what is the conclusion, my
And
lord?
then it's not that since you are representing government, you should always support the government of the bad deed or committed by this the
Yes.
engineer. If really he has committed such
My lord.
act in order to frustrate the petitioner.
Man, any mischief committed by officer, my lord, I'll never support them, my lord. It's
Yes, that-
openly I am saying to you, lordship, my lord. But
Okay,
till,
then,
my lord, till, my lord, they are proved, my lord, I believe they are innocent, my lord. This is just allegations, my lord. This happens because heart burning will be there, my lord, because they could not submit that tender paper, my lord.
My lord, I
That
leave it
feeling
to-
I can
see,
understand. my lord.
my lord, the case has been established before your lordship. This is a clear case and fit case to be interpreted by your lordship.
No, on that day also, supposing after obtaining instruction, the court satisfied. Today also, of course, some views are there, but then let him, since the line advocate, additional advocate general is praying, so we will given one opportunity, the same view will be there unless there is otherwise, Okay, on that day, the same order can be passed,
Yes.
isn't it? Same order. Okay.
Then only, my lord, I would request my council, other side council, my lord. My lord, let him clarify whether it is a company or is a farm. If it is a
I'll
company,
come-
if it is a
Because here,
if it is a company, my lord,
submission, he submitted it was farm, but then later on it
My lord, I'll be
company.
my lord,
details of the documents,
lord.
my lord, relating to this
And
company.
then if there is any
He will be satisfied, my lord.
board of directors, if they have
Yes.
decided to authorize,
then that also regulation.
also
Kindly share
on
on the
that day,
regulations,
if you
my lord.
can.
My lord.
Yes.
Okay.
Chalo, please.
The no, had Mr. Mukato, Planning Council for Petitioner, also had Mr. Rishnabam, additional AG, for a state respondent, who, okay, so the additional AG shall obtain, prays for some time to obtain necessary instruction in this regard. Okay, stop list, as prayed for, list this matter again on Friday.
This very much earlier. Well, with
Yes.
us.
No, ultimately it can.
My lord. Much earlier.
Okay.
I never thought that my friend will tangle me with my lord, farm, company, farm, my lord, that confusion. What? Time. Okay.
Yes.
Lordship, the case was filed on the year 2021. Provide
2000?
21.
And was
Item 21.
like
It's
2021, yes. It was again withdrawn. It was again withdrawn with the
Okay.
consideration of that the fact-finding committee will be established for the remeasurement of the compensation amount to be disbursed within
This is
the
regarding what?
Nigel Court.
This case is regarding what? Pertains to what?
It's a land compensation.
Rent compensation.
Yes. Lordship. Accordingly, the case was filed again on 2023.
Okay.
And the direction was given to establish a fact-finding committee to remeasure the land compensation amount. And fact-finding report have been it has been duly published and the award has been met. And since 2022, the department has lapsed in they have not make the payment of the land compensation amount. Whereas the direction has been already given from the land department also to make the compensation amount. So my humble prayer is, Your Lordship, the direction may be given to the land department to release the payment. It has already been deposited into the account of the Deputy Commissioner Upper Siam. Your Lordship may please see. The affidavit in opposition they have filed. Page number.
No, just a minute. Let us see your prayer. So the fact finding report submitted subsequently whether the
Yes.
submitted already submitted.
Yes, Your Lordship, it has been submitted. It is annexed in the page, annexure A series in my affidavit in reply, page number 99, 199 to 309.
That was after filing of this writ petition.
Yes, after filing of this writ petition.
So it was again after that, it was the compensation was recomputed.
Yes, Your Lordship.
Okay, now
Award was also been made. Award has already been made.
subsequently,
Yes.
okay, the money has been deposited.
Yes.
In the deposited to whom?
Deputy Commissioner Upper Siam.
Hmm?
It has already been deposited.
Deposited deputy to the
Yes.
for deputy commissioner.
Yes.
Now it is the compensation amount is lying with the deputy commissioner now.
Yes.
Only this amount is to be released now.
Yes, it has been to disbursed.
Disbursement or
Yes.
and you're satisfied with the finding.
Yes, Lordship, I'm satisfied.
Then
That can be done. Your Lordship may dispose of the matter directing Deputy Commissioner, my lord, based on the fact finding committee report. Whatever, my lord, amount they are entitled.
Okay.
Deputy Commissioner that will release, my lord. Not beyond that, as per the fact finding reports, my lord.
Okay, where is the fact finding?
Fact find is in that affidavit, my lord, they have annexed, my lord, is a bulky one. Yeah, no?
Page number 199 to 309.
99.
Yes, 199.
199.
199.
One, two, nine. Lama.
In the affidavit in opposition? Or
Lordship in affidavit in
hmm?
affidavit in reply.
Affidavit in reply.
Rejoinder.
Affidavit reply.
Okay.
My lord, it start from 199, my lord. So 199 till 309, my lord.
Name of the beneficiaries are listed on page number 292 to 309.
Name of the,
Beneficiaries. The petitioner, they have filed this repetition
okay.
seeking for compensation.
92, 292.
292
How
to
many petitioners are
309.
there? How many petitioners are there?
Lordship, there are 41 in
Okay.
total.
So, 292, their amounts also mentioned.
Yes, amount
Everything,
total.
chain number, my lord, everything is mentioned, my lord.
Everything is mentioned. It's
Okay,
clearly
so-
mentioned. Lordship.
Okay, this is finding by,
My lord, second number, serial number as per FFC, my lord. Fact finding committee.
mhm. Okay.
In fact, Your Lordship, they have made disbursement of 36 lakhs 18,344 to four PFs after the filing of this instant petition,
Okay.
after the release of the amount, but don't know
So
why
that-
it has been unduly
That
delayed.
which has also been mentioned there.
Yes, it is already mentioned in their reply in opposition.
Okay.
It has been made, the compensation has already been made for four PFers. But to the writ petitioners, till today, we have not received any of the amount.
Rest of the
Rest of the writ
petitioners.
petitioners.
So four petitioners have already received.
They are not our they are not in the writ petition.
Okay, they are not the petitioners.
Yes, but they have made the payment for them.
Okay, but.
The authority.
Okay, that is not connected with this. case.
Yes, not connected with our case.
So I have to take the fact.
Your more humble submission is that Your Honor may please release the payment as per the section 80 of the Lara Act 2013. There has been unduly delayed after the release of payment on the 2000 award on 2022. We haven't received any of the award. As per section 80, 15% has to be paid in addition.
My lord, why I'm agreeing, my lord, since my lord fact finding committee report, even the government have accepted, even the petition is accepting, my lord. So taking into, my lord, the fact finding, my lord, your lordship may direct the deputy commissioner. Based on the fact finding, my lord, whatever amount they are entitled, that will be released to them, my lord.
Mhm.
That order can be passed, my lord.
So your submission to release the compensation as per.
Fact finding committee report, my lord.
Fact finding committee as well as additional amount as per section 80 of Lara Act 2013. 15% amount may be addition in a per annum.
As per section.
Section 80, Your Worship.
So fact finding whether
Fact finding, my lord, chain number, amount number, everything is there.
the amount is mentioned.
Everything
Yes,
is mentioned,
everything is
chain
mentioned.
number is mentioned, my lord, amount
It
is.
says that the calculation is without solution and the rate of interest.
Yes, my
So
lord.
that will be
Yes.
given.
That-
Okay. So then, in order to bring the fact down in the order, I will have to keep it as CAB only. So I'll take the fact, huh? The first, first, I haven't gone through. Mr.
Tita tak.
You have anything?
My lord, I am respondent number 3, my lord. In fact,
Okay.
since the matter has been disclosed, my lord, in fact, I have nothing to do with the writ petition, my lord. I was just a proforma respondent, my lord. In fact,
Okay.
the stretch of work was taken over by the BRO, my lord. BRO.
Okay.
And then I have filed an affidavit, my lord. Affidavit position.
You have also filed.
Yes, yes, my lord. Respondent number 3.
Anything to be taken from that, your affidavit? Nothing.
So whatever it has to be done by the BRO, my lord.
Okay.
But we have made a party, my lord.
Okay.
In fact, I have filed an additional affidavit praying for striking of my name, my lord. But since, however, the
Praying
matter
for?
striking of my name. But then since the matter is
Okay,
already
now,
disposed of, my lord.
okay,
Only that part may be brought on record that I have filed it.
just a minute, huh? You, Mr.
Tita tak.
Line counsel for the petitioner. How many petitioners are there? 41.
41. 41 including additional 42 Your Lordship.
Additional also.
Yes, we have made the course title also, Your Lordship.
You have amended course title.
Yes, Your Lordship.
Who represent 1, 2? Okay. Mr. Oh, I have also heard Mr. Ankato. Line DSCI for respondent number 1, 2, and 4. Semicolon. And who for the respondent number 3? Okay, Mr. Ankato.
5, 4, 5, 7, 8, 9.
Okay, for the respondent number 3 and Mr. Aris Nava.
5, 7,
Planet
8,
additional AG for respondent number 5,
7, 8,
7, 8, and 9. And 6 is or 6, 7, 8, and 9. Okay. Start. Huh? The petitioner 41, 42 in numbers, huh? Basic fact in numbers, claiming to be the owner of the land, filed this writ petition under Article 226 of the Constitution of India. Prays for payment of the compensation for the land which is sought to be acquired for improvement of road at Ditedime, meaning from kilometer 0.00 to 191.00 kilometer km to NH double land specifications in the district of Upper Siang, Arunachal Pradesh. Stop. While while filing the petition, following prayers were made, where A, B, C, okay, then this is only point. Next para, during the, okay, pendency of this writ petition, who submitted this fact finding commitment? The by pendency of this petition, the land council. The land council for the petition submitted during the pendency of this writ petition. The fact finding committee, which was constituted to verify the land and asset, sought to be required for improvement of broad BTD mill, this making from kilometer 0.00 to 191.00 kilometer to any double land specification of Siang district of Arunachal Pradesh was made available. It was made available to you.
Yes.
Made available to the petitioner. Which is the starting of this fact finding in this report?
Deputy Commissioner.
199.
Yes. 199 to 309.
There is no forwarding, etc. Where?
It's in Annexure C of affidavit in opposition filed by the government, Your Lordship. Page number 17, Your Lordship.
Affidavit in opposition. Filed by respondent number.
Filed by the respondent number 7 and 8.
7 and 8. Annexure.
Annexure C, page number 17, Your Lordship.
Page number will be 185.
17. 135.
This only pointed. The Deputy Commissioner, Upper Siang, has submitted, has forwarded the fact finding committee report along with compilation details before the director, deputy commissioner, respondent number 4, huh? Yeah, 7, huh? Before the director of land management is respondent number 8. Okay, 6. Respondent number 6. We are not concerned with any other additional compensation, etc.
No, Your Worship.
Okay. So this is the only limited prayer now
Yes.
to release.
Yes.
Okay. Then Paraha, I'll manage the matter. At this stage, the land council for the petitioner submits that he has a limited prayer that since the deputy commissioner has already submitted the fact finding committee report along with along with compilation details thereof. The respondent who is to be and the compensation amount has already been released and deposited before the deputy commissioner.
Yes, Lord.
Okay, and the compensation amount has already been released and deposited before the deputy commissioner of Upper Siang District, Yingkiong, the respondent number 7, deputy commissioner of Upper Siang, Yingkiong, may be directed to release the compensation amount to the petitioners as per the fact-finding committee report, and in terms of the and in terms of the section 80 of the Lara Act. The Lara Additional Advocate General, Mr. R.S. Nabi, has no objection to the prayer made by the Lara Council for the petitioner, and submits that the amount may be released in terms of the fact as per the findings as per the report of the fact-finding committee, as per the fact-finding committee report, if they are entitled. Okay, if they are entitled as per the fact-finding committee report. And what is your to be recorded, you said? Mr. Okay. Okay, then anything to be recorded, you said? Nothing, no? Okay, file it. Okay. That will not be strike off now? No. Okay, okay. Okay. Then in there, I'll record that all the respondent, whosoever has filed the affidavit. Okay, that I'll record one paragraph. Okay, that will be sufficient for you. Okay. And any other prayer here?
Lordship,
No, that probably, and,
Your Lordship, stipulate time may be given, Your Lordship. A time may be, a particular time may be given. Your
okay.
Lordship.
Okay, in view of the above, and as agreed upon by the Rana Council for the petitioner, as consensuously agreed upon by the Rana Council for the parties, comma, this writ petition is disposed of with the direction to the Deputy Commissioner, respondent number 7. This is only structure, to release the compensation amounts to the writ petitioner. What is this PAF? No, PAF.
Project affected families.
Hmm?
Project affected families.
Project affected, okay.
Affected families.
The compensation to the project affected family, within bracket PAF, as for the fact finding report. Within how many days will be sufficient?
Money is available.
There shouldn't be any problem. Okay.
The
Within
amount is already deposited into the account of the Deputy Commissioner. Your Lordship.
account of the
Deputy Commissioner, it's already
Deputy
with the
Commissioner.
Deputy- Yes,
Okay.
30 days.
Within the period of 30 days from the date of receipt of this, and receipt of the certified copy of this order. Okay, with the above, it stands disposed of. Okay.
Obliged.
Yes,
May it please Lordship,
yes.
if the first appeal come for final hearing, with your Lordship, I got to. The appellant were the plaintiff, my lord, which has been filed for declaration of the right title interest and position, and along with the or prayer for injunction. On the suit, my lord, the appellant have preferred an application under Order 39, Rule 1 and 2 for injunction. ma'am. So initial.
Just a minute.
Lordship.
This against the order passed by Chief
Learned
Justice-
civil judge, my lord.
Civil Judge Senior Division, UPI.
Yes. Yes, Lordship.
Yes.
May I place the facts, my lord? As my lord, where the plaintiff appellant.
No, can we just, I haven't gone through, can we just read the impugn order?
My lord, before that, my lord, I have to place one first order, my lord, that is order dated 2/7/2024.
Okay.
That is page number 220. Second last page, my lord. Just start.
Order dated?
2/7/2024, my lord.
That was before the passing of the impugn order.
Yes, my lord, because it is important, my lord.
Okay, page?
Page 220, my lord, second last page, my lord. 220. Now here, my lord, what happened, my lord? At interim status quo order was passed by the civil judge, my lord. Then the defendant had appeared and filed an application under Order 39, Rule 4 for setting aside the ex parte order. Against that, my lord, that order dated 2/7/2024 has been passed. May I read the order, my lord?
Oh, just a minute, sir. First, what they have filed?
My lord, first of all, my lord, ex parte ad interim status quo order was passed by the civil judge, my lord. So we have taken steps, my lord. They have appeared and they have filed an application under Order 39, Rule 4 to set aside the said order, the status quo order. So
The
that
same court has set aside.
no, for setting aside the status quo order, they have preferred an application under Order 39, Rule 4.
Okay.
So on that application, this order was passed, my lord. Order dated 2/7/2024.
Okay.
May I read the order, lord?
Yes, please.
Appellant defendant number 1 and 2 represented by the learned counsel such and such. Learned counsel for the respondent plaintiff has filed reply in instant IA copy served. Learned counsel for the appellant defendant has filed IA number such and such under Order 39, Rule 4 for vacating, discharge, or setting aside of ex parte ad interim status quo order dated 13/3/2024 passed in 48/24 in connection with the instant suit. It is stated that the application that plaintiff respondent that the ex parte injunction status quo order by making false statement. There is important one, making false statement. In the said application, learned counsel for the appellant has submitted that respondent plaintiff made false and misleading statement in the application as respondent plaintiff in paragraph number 19 on his application and made his application relying on the order passed under section 145 CRPC by EAC Naharlagun. However, the said order of EAC was quashed and set aside by the order of Honorable Guwahati High Court, Itanagar Permanent Bench in Criminal Division number 1123 by order dated such and such, and hereby has obtained the ex parte injunction order in his favor by misleading this court. So their submission was that we have misled by suppressing this particular fact that 145 order was passed, we have not mentioned. Now, subsequently, in this reply filed by the respondent plaintiff, it is answered that plaintiff had filed the instant suit with relevant document of LPC and gift deed pertaining to the suit, and there was no reasonable ground to vacate this ex parte or injunction order. It is stated therein that the plaintiff denies suppressing material facts about the said order dated such and such. It is averred therein that order passed under 145 CRPC has no relevance in determining of the suit property. Heard both sides, learned counsel seen the application and the reply, also produced the order dated such and such passed by this court, by which ex parte ad interim injunction was granted, directing both the parties and their agents to maintain status quo over the suit land. On the perusal of the said order dated 13/3/2024, it is seen that this court was granted ex parte ad interim injunction on fulfillment of the golden principle of prima facie case, balance of convenience, irreparable loss and injury, relying on this registered gift deed Annex S, Annexure 3, LPC, Annexure Annexure 1 agreement for sale of possessory right, Annex S, Annexure 4, submission of learned counsel for appellant and averment that respondent are digging the suit land, cutting trees and considering organizing mela there, and there is possibility of alternative suit land, a possibility of alienation of suit land. Accordingly, it is seen this court, while passing the order ex parte ad interim injunction, has not relied on order passed by EAC Naharlagun on 145 CRPC and has not relied on the misleading statement in connection, if any. Accordingly, the court is considered opinion that appellant defendant number 1 and 2 has failed to make out a case. This applicant defendants are failed to make out a case fulfilling the requirement as provided under Order 39 Rule 4 CPC first provision. Accordingly, prayer in the instant IA have rejected. So their application under Order 39 Rule 4 has been rejected initially. So therefore, I would like to draw your lordship attention to Order 39 Rule 4 of CPC lordship. CPC can we give it CPC? So injunction initial status quo order was given on the application under Order 39 Rule 1 and 2. So when a ex parte order was passed, so for the defendants, it has to be under Order 39 Rule 4 to set aside an ex parte injunction order. So accordingly, they have preferred an application under Order 39 Rule 4. Your lordship got it? Order 39 Rule 4.
39
Rule 4.
Okay.
Order for injunction may be discharged.
Just a minute. Huh? Order 39 Rule 4.
Rule 4, lordship.
Yes.
Very good. Order for injunction may be discharged, varied, or set aside. Any order for an injunction may be discharged or varied or set aside by the court on application made hereto by any person dissatisfied with such order. Now this proviso, provided that if an application for temporary injunction or any affidavit supporting such application, a party has knowingly made a false and misleading statement in relation to a material particular, and the injunction was granted without giving notice to the opposite party, the court shall kindly note this out, my lord. Shall, it's a mandatory provision, my lord. Shall vacate the injunction unless, for reason to be mentioned in, considered that it is not necessary so to do in interest of justice. Now, in this case, my lord, admittedly, the injunction order was passed ex parte. The status quo order. Therefore, only remedy remains with them, my lord. To vacate the ex parte order, they have to prefer an application under Order 39 Rule 4. Accordingly, they have preferred the application. Now, the proviso of this Order 39 Rule 4 has said that they have to satisfy that the order which was passed ex parte has been obtained by suppressing or knowingly suppressing the false or misleading statement. That is the first ingredients in Order 39 Rule 4 application. So there must be a false statement, there must be a misleading statement. Only on that ground, the court which has passed an ex parte order, vacate that such order, that such kind of order, only on suppression of material fact and false and misleading statement. So in this case, my lord, the impugn order, before passing the impugn order, the learned trial court has considered the Order 39 Rule 4 application. That order has, your lordship has just read out that or Order 27/2024. Their contention has been rejected by the trial court. Court says there is no misleading statement, there is no false statement. So here is the, for vacation of that part, its matter ends here. When a ex parte injunction or status quo order was passed, only remedy available to the defendant or at the aggrieved party is to prefer an application under Order 39 Rule 4. They have rightly preferred an application under Order 39 Rule 4. And after considering, and my lord,
Where was the last order? The first order?
that was page number 220, my lord. We have annexed this order
Yes,
dated
yes, 220.
220. Order dated 2/7/2024.
Wait. That's it. Okay, where is the order dated, this one? 13/3/24?
This High Court order, my lord.
13/3.
13/3, that is the order of
The interim status quo order.
interim order, lordship, 13/3 order. That is page 196.
196.
196. Page number 196. May I read, lordship?
Yes.
May I read, Lordship, the
Yes,
first
please.
initial order, my lord. The learned counsel for the applicant plaintiff has filed an instant IA under Order 39, Rule 1 and 2, reduced Section 151 CPC, paying for a grant temporary injunction along with a prayer for granting ad interim injunction to remove obstruction over the suit land, preserve status quo on the suit land during the pendency of the suit. It is averred in the plain that the application that the suit land measuring 24,360 square meters is located at a sector model village Naharlagun, out of which plaintiff was gifted 18,860 square meter of land by a registered gift deed dated such and such by proforma defendant number 3, and with regard to part of the suit land measuring 5,500 square meter on agreement to sell possessory right over a land deed dated 1/5/2015 was executed between plaintiff and proforma defendant number 3. It is stated therein that the plaintiff has been in possession of the suit land since the year 2015. That on 4/1/2022, respondent defendant number 1 and 2 had encroached upon 10,360 square meters of suit land, that is 4,860 square meter out of the gifted land of 18,860 square meter and 5,500 square meter which were under possession and execution of the agreement for sale possessory right over the land. It is averred in the application that prior to execution of the registered gift deed, proforma defendant number 3 has LPC gift land measuring 18,860 square meter, bearing LPC number such and such of 2004, dated UPR D 13 August 2004. It is further averred in the application that the respondent have not only dug the suit land by engaging JCB and excavator and thereby causing damage to the nature of the suit land, but have also cut down valuable trees over the suit land and also constructed hard and barbed wire and organized mela bazaar over the suit land. It is further averred in the application that the injunction is not granted as prayed for there is a possibility of alienation of the suit land by the defendant. Learned counsel for the application has submitted, applicant has submitted that the suit land measuring 24,300 square meter is a barren land which was used by the applicant to dump waste machineries of the industry's service station location in the land nearby to the suit land, and respondent have encroached upon 10,300 square meter of suit land by erecting concrete cement post, and that applicant is possession of the remaining 14,000 square meters of land at present. Third, seen the relevant principle of law granting ex parte ad interim injunction in Golden Pencil prima facie case, balance of convenience, and irreparable loss and injury, etc. On the perusal of the record, it is seen that in view of the registered gift deed in favor of the plaintiff annexed as Annexure 3, LPC of the donor annexure as Annexure 1, connection of the part of the suit land measuring 18,800 square meter, and agreement for sale of possessory right annexed as Annexure 4. In connection to part of the suit land measuring 5,500 square meter, the applicant plaintiff has been able to establish a prima facie case in his favor. Further, as per submission of the learned counsel for the applicant, since 14,000 square meter of land is in possession of applicant plaintiff and the entire suit land was in the possession of the applicant plaintiff prior to the encroachment, and the respondent have only erected cemented post, barbed wire, etc., the balance of convenience is also in favor of the applicant. Furthermore, irreparable loss is likely to be caused to the applicant if ex parte temporary injunction prayed is not granted, considering the averment that respondent have been digging the suit land, cutting tree, organizing mela there, and there is possibility of alienation of the suit land. Further, due to risks of alienation, the suit land and the changes made to the nature of the suit, land is the urgency also established by the applicant. In view of all this above, the court of the considered opinion to grant ex parte ad interim temporary injunction and direct both the parties and their agents to maintain status quo over the suit land until next date. Application shall comply with the requirement of under Order 39 Rule 4 provision CPC tomorrow. Issue notice in respondent such and such. So accordingly, applicant have complied with the provision of three provision, my lord, issue notice to the respondent, and they have appeared after appearance, my lord, they have filed this application under Order 39 Rule 4.
Yes.
So, an objection to the injunction application which was filed by the plaintiff, they have also filed an objection to this application, our application, my lord, along with the Order 39 Rule 4 application. They have filed an objection to that one. My lord, after rejection of this order, Order 39 Rule 4, the learned civil judge finally, my lord, disposed of the injunction application on the same ground which the earlier application under Order 39 Rule 4 has been rejected. So, your lordship now kindly peruse the impugn order, that is 199 page.
199.
This is order dated
Yes.
37/2024.
Yes.
The earlier order which was rejected, that was passed on 2/7/24. On the same context, my lord, this impugn order was passed, my lord, on 37/2024, my lord.
This application is an IA is for
Application has been filed, this is order dated 37/2024, page 199.
This is impugn order.
That is the impugn order, lordship. That is the impugn order.
Okay, just a minute. This is separate application.
No separate application.
In the same application.
On the application which we have filed, my lord, under Order 39 Rule 1 and 2, the learned trial court was pleased to pass an ex parte order. To vacate that ex parte order, they have preferred Order 39 Rule 4 application, my lord. That has been rejected. After rejection, this particular, my lord, this impugn order was passed, my lord.
So this order was passed in the same IA.
Yes, yes.
IA 8/2024.
Yes.
This was not disposed of while rejecting the order.
No, my lord. In as per the CPC, my lord, when ex parte order was passed, only remedy was to file an application under Order 39 Rule 4. They have accordingly preferred. The ground is that they are misleading and false statement. Court has rejected their application, said that there is no false and misleading.
This their application under Order 39 Rule 4
Rule 4.
has been rejected by Order dated 2/7/24.
Yes.
Okay, this is separate number. Okay, this is IA. That was
That is
IA.
IA,
That was
that
okay.
is-
That was IA.
Yes.
Okay, and then this is the impugn order was passed.
The connected title suit is number 9 of 2024. That is the my lord connected suit.
In title suit number.
Yes, 9/2024, my lord.
2/7/24, 37/24. This IA number 8/24 in title suit number 09 is the same IA where the interim
Yes.
status quo order was passed. Okay, so this is final disposal.
There was final disposal.
37/2024.
37/2024.
Final disposal of the IA in title suit number 9.
Yes.
Okay. Yes.
Now, may I read lordship?
Yes,
this,
please.
From the third paragraph, my lord. For the instant application has been filed by the applicant plaintiff under Order 39, Rule 1 and 2, read with 1, Section 151 CPC, praying for granting temporary injunction to remove the construction about the suit land during the pendency of the suit. It is averred in the plaint and the application that the suit land measuring 24,360 square meter is located at a sector model village Naharlagun, out of which plaintiff was gifted 18,860 square meter of land by the registered gift deed dated 7/4/2015 by performer defendant number 3, and with regard to the part of the suit land measuring 5,500 square meter, an agreement to sell a possessory right over the land dated 1/5/2015 was executed between plaintiff and the performer defendant number 3. It is stated therein that the plaintiff has been possession of the suit land since year 2015. That on 4/1/2022, respondent defendant number 1 and 2 had encroached upon 10,360 square meters of land, that is 4,060 square meter out of gifted land of 18,800 square meters and 5,500 square meter which were under his possession after the execution of agreement for sale of possessory right over the land. It is averred in the application that prior to execution of the registered gift deed, the performer defendant number 3 had LPC of the gifted land measuring 18,860 square meter, bearing LPC number such and such of 2004. It is further averred that the applicant that the respondent have not only dug the suit land by engaging JCB excavators, thereby causing damage to the nature and the suit land, but have also cut down valuable trees over the suit land, and also constructed hearth and barbed wires and organized Mela Bazaar over the suit land. It is further averred in the application that if the injunction is not granted as prayed for, there is a possibility of alienation of the suit land by the defendant. The learned counsel for the opposite party, defendant number 3, has submitted that has no objection to prayer made in the instant application and has not filed any reply. In the reply filed by the OP defendant number 1 and 2 counterclaimant, it is averred that OP defendant number 2 is the owner of the suit land mentioned in the Schedule A and B of the plaint. The applicant is illegal possession of 14,000 square meters of land mentioned in Schedule A. The land mentioned in Schedule B is the land fall under LPC area of opposite OP number 2. It is averred the applicant was never in possession of the suit land. The except of SPT building and the boundary is a small portion of the suit land under the possession of the applicant has been developed and invested on any part of the suit land. Under possession of OPs, on the contrary, OP have developed the suit land under the possession by constructing SPT house under occupation of tenant and a OBT house from the where tenant is running timber business. In addition, construction of RCC culvert was undertaken and same was stopped after status quo order. Further, it is stated that therein the applicant deliberately suppressed above order dated 23/11/2023 in criminal division petition that is such and such passed the Honorable Guwahati High Court, by which proceeding initiated under Section 145 by the executive magistrate was set aside and quashed, and also suppressed that the fact that Schedule B land fall under LPC area of OP number 2, that the application has not approached the court with clean hands, and by making false statement, he obtained status quo order dated such and such from this court, and therefore same deserve to be vacated. The OP number 2 constructed aforesaid structure in the suit land under his possession in January 2023, but applicant remained silent and only after more than 1 year filed instant suit, and so the account of delay and laches also apply. Application is not entitled for any temporary relief. It is averred in the paragraph 8 of the reply that OP 1 and 2 have made out a prima facie case that in their favor and balance of convenience lies in their favor. It prayed that OP be allowed to complete the construction of culvert to enable vehicular movement to the suit lane, and it would not change the nature and character of the suit lane. And both the learned counsel and the case record and the case law relied upon the learned counsels. Now, the three golden principles of grant of temporary injunction under Order 39, Rule 1 and 1, CPCI, prima facie case, balance of convenience, irreparable loss and injury laid down in several judgments. On joint reading of the application and reply file, it is seen that both parties have averred that prima facie case is made out in their favor. Respectively, since applicant has averred that it was registered gift deed and agreement to sell document to make out a prima facie case in their favor. On the other hand, OP number 2 has averred that it has LPC on the part of the suit land and thereby has a prima facie case. In addition, both the parties have averred that they have possessed different parts of the suit land. Applicant have averred that on the date of filing of the suit applicant has possessed 14,000 square meter of land. OP number 1 and 2 has jointly encroached 4,860 square meters of suit land. Also, applicant has averred in paragraph 8 of the applicant that it has first week of January 2022, the defendant illegally entered into 4,800 square meters of land, Schedule A, and 5,500 square meter of land in Schedule B. On the other hand, OPs have averred that suit land is under the possession of the tenant of OPs are already staying in part of the suit land, and OP have already started construction of culvert to enable the valuable vehicular movement in the suit lane and annex related photographs. Thus, it is seen that both the parties have averred that balance of convenience in their possession. Seen that the decided case of MS such and such reported in 87 Supra CPC Supreme Court. It has held that the Honorable Supreme Court, if plaintiff was not in possession and sought granted for injunction was unwarranted under Order 39, Rule 1 CPC. From all these above, the applicant plaintiff is not in possession entire suit land, and therefore balance of convenience is not in favor of the applicant for grant of temporary injunction. Further, it is seen that paragraph 19 of the application, the applicant has averred that the order passed by the Deputy Commissioner, EC, ADC, Executive Magistrate are sufficient to guess that balance of convenience in heavily in favor of petitioner for granting interim order of injunction. However, it is seen that applicant deliberately suppressed about order dated 23/11/23 passed in criminal revision petition by the Honorable Guwahati High Court, Itanagar bench, by which proceeding initiated under section 145 CRPC by the executive magistrate was set aside and quashed. Seeing that the order copy of annexure P32 of Payne is seen it has been laid down in several judgments that grant of temporary injunction is an equitable relief and party paying for the grant of same should come with clean hand. As seen from the above highlights facts, applicant had suppressed the facts about the aforesaid order passed by this Honorable Guwahati High Court to make his statement that the balance of convenience in favor thereby has not come with the clean hand and seeking the relief of temporary injunction, and thereby it is not entitled to relief of temporary injunction as prayed for instant application. Furthermore, the peruse the decided case of such and such, when it was held that the Honorable Apex Court at 20 granting of injunction of equitable relief, a person who had quit for a long time allowed another to deal with the properties exclusively ordinarily would not entitled to order for injunction. Now, it is instant case, it is seen that it is averred in paragraph 8 of the applicant by the applicant plaintiff that the first week of January 2022, the defendant illegally entered into 4,860 square meters and land and schedule of Schedule A and 5,500 square meter of land in Schedule B, but instead of application and related title suit was filed only on 2024 by applicant plaintiff after a huge delay. Therefore, from above, it is clear the applicant plaintiff kept quiet for a long time, that is the period between 22 and 2024, and therefore the application is entitled for relief without temporary injunction. And in the view of the above, highlight facts, case law paid for IA such and such is thereby rejected. So that was the impugn order was passed. Now, in the impugn order, which was highlighted, these facts which was highlighted were carried forward by the on the basis of the application which was filed under Order 39 Rule 4. The same facts has been considered while adjudicating the Order 39 application and rejected their application. On the same and similar circumstances, on the same facts, court has come down with a finding that the petitioners have suppressed the material fact deliberately, and there was a delay of 2 years. Where is it? I would show your lordship, there was no delay at all. It is the suit was filed instantly in 2024 when they have encroached upon the suit land from their pleadings itself. So there is a totally wrong finding based on their totally wrong adaptation of a principle of law, and come to the conclusion that and my status quo order has been vacated. Now, while dealing with this impugn order, my lord, the trial court said that we have deliberately suppressed a order of a high court, which was passed under of an application under order of section 145 CRPC to maintain peace and tranquility in the society. A totally different footage, my lord, and which was they have preferred, my lord, an application criminal revision application before the High Court, and there is no right has been created by the petitioner or plaintiff by such order. I would like to show that order also, if lordship was pleased to see the High Court order. So, my lord, time also.
So after this, what happened to the PS title suit?
Title suit is pending, lordship.
Pending.
Is pending.
Posted for ADR.
It was posted for ADR. It was posted for ADR, my lord.
Alternative.
Proceeding.
Proceed.
Okay. Okay. Now,
my lord, on 3 count, my lord, the Lynette civil judges dismissed my order 39 Rule 1 application, and the order passed earlier, my lord. That is on basis of possession. Secondly, my lord, separation of material fact and my lord, material fact and false statement, and they were delay, my lord. On these 3 counts, my lord, the Lynette civil judges dismissed my application, my lord. My lord, but in this present application, my lord, the first application which they have preferred, my lord, order 39 Rule 4. On that application, they have said that we have suppressed the material fact. And on the suppression of material fact, they are seeking for cancellation of the status quo order. And that part also considered while passing the order dated 2/7/24, which was the order 39 Rule 4 application they have preferred. That part has been considered.
and in this order dated 30 also.
Yes, that part was considered that there was no suppression of fact, and we have seen that the order of the High Court, but there was no suppression of fact. My lord, first.
And by this impugn order, they reiterated that there was a suppression.
And subsequently by impugn order, the court held that there was a suppression. Whereas on the same material fact, if there is some other material fact has been brought by the other side, my lord, defendant, there would have been different finding, my lord. But on the same material fact, which was brought by the defendants, my lord, first of all, on Order 39 Rule for Application, court has rejected their contention that there is no suppression of material fact, and we have considered. We have considered after consideration of the all the material fact and the golden principle.
Their application for vacation of the interim status quo order was rejected. After that, this 37/2024.
Yes, yes.
On one occasion, and how it was considered again.
That was the question before your lordship to decide, my lord, whether the same similar court on a similar facts and circumstances can give a two separate views. And that is the appeal about, my lord, all about on this context, my lord, whether a particular facts and circumstances which is placed before the same court can pass to different views.
Today, will we be
It
able
will
to-
be take time, lordship, but
Take much time.
Hmm.
My lord.
He is yet to submit. This is only the.
yeah, more to submit, my lord.
No issue.
Just I have given the.
He wants another day also, no issue.
I have to be because my lord is a time doesn't permit my lord.
Otherwise, if my lord allows me to do, because his entire case is fixing these two orders, I clarify the issue. I think my lord will be clear, then matter can be easily discussed. Otherwise, it's a very simple, so things are there.
Okay, just wait for some time. You'll submit. Let me just ensure if just clarification if there is any.
Yes.
You'll submit. I'll give you an opportunity. Okay, just what is the?
Different order. How I see. First is then generally what happened. When the title suit is fine. So title suit was filed. Title suit 9/2024 was filed by him. Along with this case number 8 of 2024.
Yes.
The miscase was claim for ground of temporary use. Now, my knows at the first stage, ex parte order was issued. I will kindly take note of the word ex parte. Because on the first day, we were not represented. Ex parte order was passed.
Yes.
Yes. So when we saw the ex parte order, then we filed the application under order rule 4. Particularly without raising the issue of those whether prima facie balance of convenience, all those issues are not raised here. Only one point that there was a suppression of fact. Now the learned trial court has rejected that application. Kindly turn to the page on what ground, then matter will be very clear. Now what he is trying to do now is like to taking that part and saying that this is a contrary observation. No, that is not the conclusion. Can you tell the page 20?
Yes.
Page 221.
Yes.
Just read second paragraph. From the bottom, you will see 11. From the bottom, 11 line. Accordingly. Now we have to understand. Your Honor, this IFOPA it was filed not on another ground because main injunction application was still pending. Your Honor, is very much point. The main injunction application 8 was still pending. So my application was only for setting aside the ex parte order because that was passed without hearing. And the limited ground was only that some suppression of fact was made. Then the learned trial court has observed, may I repeat?
Yes.
Accordingly,
Yes, please.
accordingly, it is that this civil court, while passing the said ex parte implementation, has not relied on the order passed by AC so and so, and has not relied on any misleading statement in connection so and so. Now, Your Honor, here I pause for a moment. Now, what the learned trial is that ex parte order, while passing the ex parte order,
Honorable Court only considered the other aspect, prima facie case, all those things, and did not rely on those misleading statements while passing the order. While passing the ex parte order, learned trial court said that I did not rely on the order, or those suppressed material facts. Therefore, the ex parte order was passed without relying on those suppressed facts. Therefore, this is clear. Now, my lord, this matter ends. This matter ends there. Now, my lord, friends should not have brought this matter before this honorable, because this issue is not before this honorable. Right. This order, this judgment is not under challenge. Now, my lord, what is the issue before this one? That at the time of disposing the main IA number 8, my lord, IA number 8, because that has to be disposed after hearing both the parties. IA number 8 was pending, madam, where the ex parte order was passed. Now, once this suppression of fact, because land tribunal is not the
Now, see, the IA number 8,
yes,
granting
ex parte,
ex parte status quo order,
yes,
this need to be disposed of because you filed application for vacation of the ex parte status quo order that was rejected. After rejection, whether this need to be disposed of.
now because that my IA,
Because the suit is pending, suit has to proceed.
now I am speaking. Now the main IA was pending 8, the main IA.
Yes.
Then this main IA was pending where ex parte order was passed. In the meantime, I filed one IA for PA for vacation of the ex parte only on the ground of suppression. Other issues are not considered. Now, my is to consider because ex-wife deciding whether rejection has to be given.
So here in IA 8, you have filed objection.
Yes.
Affidavit.
Yes.
Okay.
That is pending. So this 48 has been dismissed and IA 8 has been separately considered. Why this 48 IA number 8 has not been disposed of? Because IA number 8, IA 48, my lord, this is not regarding other principle, whether there is a balance of convenience, prima facie case, all these aspects are not raised here. So the London Trial Court, this IA, this CPC provision is set. This application is something like that. This application is filed saying that some statement has been misleading statement has been made. Then in that situation, it is mandatory that the court has to vacate out. Now, the London Trial Court says that why when I issued the ex parte order, the board is ex parte order, I did not rely on those facts. That's why rejected. Now, subsequently, after hearing all the parties in main IA, which is the interim order in this case, then the London Trial Court has dealt with all the aspects like prima facie, all this golden principle, and again has dealt with the aspect whether there was a suppression of fact or not. Because suppression of fact or not, that was not discussed in 48. Only that was whether I relied or not. The London Trial Court did not rely while passing ex parte order. So, but at the final disposal of the IA, exhaustive hearing has to be done. Entire matter has to be considered because 48 is very limited. Only on the point where the ex parte order was obtained by suppressing the fact. Only on that issue. Now, what my learned friends tried, that since section this 48 IA, that deals with only suppression, that deals with ad infim order. Since once in ad infim order, the learned trial court has said that no, now what he's saying that now therefore in IA number 8, court cannot discuss anything.
No, because what he submits is since the ex parte status quo order, the setting aside of the ex parte status quo order was rejected, considering these three principles, golden principle.
No.
While disposing of the IA for setting aside, this three golden principle
My
was
lord,
not.
may I submit, Lordship?
Yes. What thereafter? After rejection of the vacation order, what next, according to you? After rejection of the vacation order, vacation application, they have filed application for vacation of the status quo order.
My lord.
What
Yes, my
is
lord.
the steps?
As per the CPC, my lord, when ex parte injunction petition has been granted, ex parte order has been.
Yes.
If the aggrieved party approach the honorable court under order 39 rule 4, because that is the only provision where CPC said if the ex parte order has been granted without hearing the other side, they may prefer under order 39 rule 4 on the condition. That is the proviso, my lord.
Yes.
That is my line, but I skip, my lord. That is the proviso on suppression of material fact or false statement. And accordingly, they have agreed. A order was passed ex parte. They have been aggrieved with that order. So their remedy is available under order 39 rule 4. That is the only remedy available to them.
They file.
Because the order was passed ex parte, they have to prefer an application under order 39 rule 4. So if the order was passed inter party, the court cannot reject the interim order. That was the further provision also clarify on that. But when it was passed ex parte, only this suppression of material fact or misleading statement, the ex parte order can be set aside. That was the only provision in the CPC where the power to the honorable court has been granted. If the court has satisfied that the order was obtained by misleading or false statement. So first prima facie, my lord, first ingredients of rejecting an ex parte order is to be on the basis of a false and misleading statement. First ingredient
is only two.
Yes, first ingredients. There must be a false and misleading statement while obtaining an ex parte order. They have failed to show that we have misled the court and we have false statement given while obtaining the interim order. So that was a clear finding by the trial court while disposing of their application order 39 rule 4.
Yes.
Now my learned bar want to say that further court can dispose of the ad interim injunction finally on the same material fact. If some other material fact come before your lordship or the trial court can definitely pass some order. But when court has rejected their application, their prayer, there was no suppression of material fact, which they have said that these are the suppression of material fact. Court said, I have considered that material facts, and despite that, I have passed the ex parte order. So while passing this impugn order, court has considered again the same material fact which they have brought into record. The first of all, under order 39 rule 4 application.
No, after rejection of this order 39 rule 4, what next? Next option, next remedy for the respondent.
Well, they have to file another application if we have suppressed or another suppression of material fact.
Whether this IA filed by you 8 can be disposed of apart from, because
No, here is the question is that, my lord, the findings subsequently, the impugn order which was passed by the trial court, my lord, the finding which was given is arbitrary. Because the finding which was given earlier in the IA, which they have filed under Order 39 Rule 4, on the misleading and false statement, court says rejected that. There is no misleading statement or false
After
statement.
rejection, what next? To do with this IA?
They have to continue with you till disposal of the suit.
That is why.
Yeah, till
Is there any other provision allowing for disposal of this IA? IA, according to you, cannot be disposed of.
No, finally it can be disposed of.
No, finally,
Yes,
after
yes.
the disposal of the suit
Yes, yes,
itself.
finally can be disposed of.
Yes.
But for disposal of ex parte order, final disposal
No,
and
for disposal of ex parte order, they have filed order 39 rule 4 that has been rejected.
rejected.
Now, after rejection, what next?
No, only after when court has rejected.
This IA has been conceded, that has been disposed.
No, that
Now,
then
whether
whether
it is
IA
coming-
thereafter IA can be separately disposed of as has been done here in this case.
This
My
IA
lord-
was pending, my lord.
No, just a minute. Can it be?
No, my lord, my trying to convince your lordship because in CPC, my lord, when an ex parte order has been passed, that only can be vacated through Order 39 Rule 4 application.
That is why I'm saying that order 39 rule 4 application they have availed it that was rejected.
Rejected
And
thereafter.
after that, whether the court can take up this again.
No, that
IA.
cannot be. There has to be finally disposed of.
Yes.
That has
That
to
is
be.
what I'm saying.
Yes.
Trying to say.
That has to
Is
be.
there any
fin-
is there any provision to dispose of separately as has been done in here in this case? Here
No.
in this case, thereafter they have disposed of.
Finally,
Final disposal.
No.
So this amounts to
the injunction application has to be finally disposed of. Here are two provisions, lordship.
finally disposed of while the suit is still pending.
It has to be. It has to be finally disposed of. But for setting aside the ex parte order, that is why Order 39 Rule 4, lordship. That is why Order 39 Rule 4. Except Order 39 Rule 4, court cannot go beyond Order 39 Rule 4 while.
Okay. So, but then this injunction application can be disposed of while the suit is still pending.
Yes, yes. Yes, it can be done. It can be done. Court can given finally dispose of also. Final injunction order can be passed. An interim order can be passed. But here, what happened, my lord? Here on the facts.
So by this impugn order, this IA injunction application has been disposed of. Just a minute. Whether this has been disposed of.
Yes, my lord. This finally is IA where the interim injunction order was passed, that has been disposed. And during that time, now, my lord, let's come to another. Let's for a while, let's say. For consideration of whether injunction order is to be granted or not, so many factors are to be considered. Now, now, my lord, this time. Now, my learned friend is mixing both these together. Now, this IA is pending there, where ex parte order was issued without hearing me. That application has to finally disposed of. My application is only on the limited ground that they get the aid implementation, not for.
Now, here by this impugn order also, the interim impugn order has been vacated.
By final impugn order, his IA has been disposed.
And the impugn order.
By impugn order has been disposed, and this interim injunction order has been vacated. After hearing both the
Because that is what he is saying.
That is my point.
That this injunction petition can be finally disposed of, but this ad interim
Order cannot be-
status quo order against which you have filed application for vacation has already been rejected earlier.
Here is the thing. He is trying to confuse all that. Here is the thing. Well, kindly. Now, my application is not on the merit of the entire application. My separate objection is, main hearing is to take place so far IA is concerned. We have done.
Which according to you has been taken here by
Yes.
disposing of this?
Yes.
Okay.
Because.
Okay, anyway, today we're time, we have no.
That's I will other argument. Let's say that this suppression of fact has no relevance at all. Why? Our injunction order is granted under what basis? But then it's over there. He makes it. I will make clear. It's mixing
Please,
both the things.
Because the interesting point of law is involved lordship
Yes,
because
as point of law, sir, law point, on that they try to satisfy.
yes, I will satisfy lordship. Well, here apparently, my lord, two order has been passed on the similar facts and circumstances, my lord. That is the
So
issue here.
when do we fix?
এটা করবো। কখন? I don't know. I will-
Is it possible of the fourth? Because cases. Fifth. I will be coming you. Kindly can be some. Wherever I am ready to accommodate. Whenever I am available. 11.
Mr.
I am Shiladitya lordship.
Hmm?
I will give my name, my lord. Shiladitya.
Okay, Planning Council for the appellant. Also had Mr. Rajesh Sona, Planning Council for the respondent. Okay.
When will you want to use? Yes, yes. Let me check.
I think for me, whenever I
Yes,
if
yes.
I am outside.
Message to police. I will give it the name. 12:41 again, 12.
Hearing remain
On 12 of
inconclusive.
August, lordship.
12 August,
August.
hearing remain inconclusive. Is
12
requested. Let the matter be listed on 12 August. 12 August.
12 of August.
Okay. Okay.
My lord, there was a status quo order passed earlier, my lord. That may be continued.
No, my lord, this is
No.
status quo order. My friend, I think he should know.
No, when you have already.
Any order passed?
Earlier, in the.
No, here in
initial-
this case.
No, yes.
No,
For the
the-
First order, my
First order, thereafter, my lord, he has been repeatedly saying
first
every
order-
hearing, my lord, this has.
No, not every hearing. It was skipped out when the matter was mentioned, my lord. It was skipped out that interim order was not continued, my lord. There was no specific order,
My lord,
discontinuation of the interim order.
But I don't last occasion. my lord,
While
my lord,
mentioning,
still
it was
order.
left
Yes, while mentioning, my lord, actually-
Initial order was still.
actually they have-
Thereafter, my lord, after hearing me or thereafter, this has not been extended. my lord, till date, my lord.
After, it was extended till January.
My lord, thereafter not extended. my lord.
No express order was.
No, there was no
But-
express order because, my lord, they have mentioned the matter, my lord, and it was left out. It was left out.
This is every time, last occasion,
Wait.
also, my lord, declined by this honorable court.
It was not declined. It was said that it was.
It was declined since initially this order was not extended. Therefore, my lord, if my lord, there is the order, my lord. All this order, my lord, this status quo has not been extended. My lord, how status quo? My lord, this is the case. Evidently, LPC is with me, title is with me, possession is with me, everything is with me.
No, for that, my lordship, I have to.
But this has not been extended, my lord. Last occasion also,
No, but-
before that also. my
Where,
lord,
So, okay, we'll finally dispose of on
Yes,
12 August. Okay.
my lord, here is a application filed under Order 39, Rule 110(2). On that application, injunction order, status quo order was granted, my lord. If they have aggrieved, my lord, if they have aggrieved, they have to file a proper application for vacation of the status quo order. It's a regular suit. It's a regular
What
appeal,
we'll do,
lordship.
we'll see next date if finally if it is not this.
Till that,
disposed
my
of-
lord, till that, my lord, status quo order should be continued
This has not
because.
been extended, my lord. And
No, no,
my
there
lord,
was no
this is-
specific-
This entire, this appeal itself, my lord. when
No,
it's
if,
so
if,
very-
if my learned
This
brother
has
want
not
to
been
say,
extended, my lord. To be, my humble
Lane,
suggestion,
Lane is under whose possession?
my lord.
Lane is under whose possession?
My lord.
no admission at all. After consideration of the facts and circumstances by this honorable court has passed the status quo order, my lord.
No. My lord, even
So if you are agreed, you can file.
My friend, I think once repeatedly this honorable court declined for the extension of the.
There was no specific order for declaration that.
Last
Okay,
occasion,
and
this
if-
case
and
was
if-
declined.
and on the next date, we'll try to dispose of the entire matter. Okay. One more matter. Who is there? Council is present. No one appears on behalf of anyone? Present. Should have informed. Okay, on, Mr. Okay, Ghana Council for the petition. Where is the petition? None appears on behalf of the petitioner. This is made again tomorrow, huh? No one appears on behalf of the petitioner on call, huh? This is made again tomorrow. Okay. Get it listed tomorrow.